Please the court, I appear with Ms. Armstrong.
And there's no appearance by either of the plaintiffs. I assume that your instructors received the same email that we received a very short time ago, and seen to whom it was addressed. How we should proceed, you also would have got this morning the yesterday. Where do we go from here?
As I understand the email, it apparently has been sent to me. I don't have, as things presently stand, access to my emails. It's been explained to me, however, the position is that the plaintiffs seek or intend to be here at 11:30. Now, given that it's now coming up to 20 to 11, and given that, I think Mr. Cooksall, and trying to put this as neutrally and fairly as possible, late in the day yesterday he was given an opportunity to continue to participate, that is, by watching via the livestream. He chose not to take that opportunity. But in choosing not to take that opportunity, it might be said that he didn't have the chance to say at that point that he might need to be late because of pre-existing commitments, etc. Taking that fact into account and attempting to be as fair as possible to Mr. Cooksall, I think it's probably the most prudent approach that the court give him until 11:30 to be here. But I should say that when he does get here at 11:30, there are several things that I'll be seeking to say to the court in respect of, or in furtherance of, and perhaps in reply is the best way to put it, to what Ms. Zhu has said thus far, in relation to Your Honour's requests for us to address the issue of how the proceeding or how the trial should proceed from here. At the moment there's probably 4 broad topics that I would be wanting to speak to. One of those topics would be relevant to a latent concern Your Honour might have about the appropriateness of the submissions that I made about the matter proceeding on the papers, insofar as it concerns Ms. Zhu. Plainly, much of what I had to say yesterday was directed at the disgusting behaviour that Mr. Cooksall engaged in, which is on the video and on the transcript, and there's no need for me to go back into the detail of that. The same of course can't be said about Ms. Zhu. She has done her best, I think, in fairness to her, to act appropriately and deal with the issues as they've arisen. That is with one significant exception, however, and I want to make submissions about this, and that exception is the extent to which he has now provided the court with what is in essence a roadmap of her intention, to use this proceeding to abuse the procedures of the court. She said a range of things about her intention to want to try and play 4 hours of audio recordings and things of that nature, evidentiary issues that of course in a different type of case might be relevant, but
this is not a merits review.
Indeed, Your Honour. You have to decide, with respect, whether there's been an error of law or a jurisdictional error, and we say that you perhaps don't even get to that point because there's utility questions, there's abuse of process questions that come before that.
It's probably not worth pursuing further in their absence.
Indeed.
But I might and I will indicate when they are live, reflecting upon the most efficient way forward. It seems to me that, and I'll repeat this when they arrive, that it does seem to me that rather than waste another 2 hours this morning arguing about whether or not I've got the power, which I clearly do have, to make certain directions, and how we'll just get on with the trial, and if it is not possible to continue, or if I need to make further directions, then I'll do that.
Yes.
And we'll just see what the situation is when they arrive, but I'm keen to just get on with it.
If the court pleases.
So I'll leave. I'll return at 11:30, and we'll continue to go on to emails to whether or not anything further comes in. That's really the only course.
Thank you, Your Honour.
Your Honour, I'd like to be heard. There's a number of matters, including the matters in relation to which I emailed the court.
So in addition to the matters that are in that affidavit of service, Your Honour.
Sorry, Your Honour, I thought you were considering.
No, I was just responding to the time. Please be seated. I just want to hear from Mr. Brereton, and then I'll come back to you.
No, this is an urgent matter that I wish to advise the court. This is most improper.
Mr. Cooksall, you advised the court this morning.
I don't know what has been saying. I've not, yes, and I had advised the court while I was running.
Yes, that's okay. I also note that at 11:52, Ms. Zhu also appeared.
Your Honour, I need to be heard in relation to matters. Ms. Zhu has been extremely agitated and disturbed, in part because Your Honour kicked me out to facilitate a character assassination.
Mr. Cooksall, please sit down.
For the transcript by Mr.
Cooksall, please sit down. If you don't sit down...
No, he used words like disgusting about me.
Mr. Cooksall, would you please sit down?
Despite the fact that he knows about my mental health illness.
Mr. Cooksall, please sit down.
Through confidential information that he has received as part of my complaint to the IBAC.
Mr. Cooksall, please sit down.
Your Honour, this was.
Mr. Cooksall, please sit down.
It was repugnant to the law.
Mr. Cooksall, please sit down.
I do not intend.
Mr. Cooksall, please sit down.
I'm not going to.
Mr. Cooksall, please sit down.
Sorry.
Mr. Cooksall, I think I'm up to 8th time to ask you to please sit down.
Because you're not listening to me.
Mr. Cooksall, if I don't...
I'd like to be heard.
I've asked you to please sit down so I can continue to hear from Mr. Brereton and then I'll come back to you.
No, I'm not going to hear the trial that his arguments about. I have a right to address the court about urgent, pressing issues that are making it impossible for us to sit here and listen. We're medically incapacitated.
There's no evidence of that, Your Honor.
What you're doing is cruel and degrading treatment.
Mr. Kuxel, please sit down, or I'll have to ask you to leave the room.
You can physically remove me. I will cooperate with that, but I will not willingly participate in my oppression in this way. He's simply presenting his case at trial. We wish to be heard about urgent matters that are creating excruciating difficulty for us, and you're refusing to hear that. What sort of a court is this?
Mr. Kuxel, I've asked you to please sit down so I can.
You can remove me, but I will not.
Mr. Kuxel, please sit down and stop talking.
No, I will not.
Mr. Kuxel, please sit down.
Your Honor.
Mr. Kuxel, please sit down.
I am not.
Mr. Kuxel, please sit down.
Going to sit. I am not feeling well. I'm not going to sit.
Mr. Kuxel, please sit down.
Listening to, I'm sorry, I'm not, I don't think you're listening to me.
Mr. Kuxel, you aren't listening to me, and I have asked you to please sit down while I continue to hear.
I'm saying I'm incapable of listening to you at the moment because of what is happening.
Mr. Kuxel, please sit down or leave the courtroom.
I'm not going to willingly leave. You can physically remove me. I will cooperate with that like I did yesterday, but I'm not going to cooperate in the fuss of a transcript.
Mr. Kuxel, your behavior is totally out of line.
No, it's not.
Please sit down or leave the room.
It's not. It's the most civil way in which I can protest what's going on.
Mr. Kuxel, please leave the courtroom and stand outside the courtroom.
I will not do it of my own volition. If you are asking me, if you're ordering me to leave, I will do that. I will comply with that, irrespective of my belief that the order is unlawful and in perpetration of fraud.
Mr. Kuxel, you are disrupting the court proceedings.
I wish to be heard about an urgent, pressing matter.
And I said to you,
you're refusing to hear me.
I did not say that at all.
You're allowing him to continue with the presentation of his trial.
I did not say that. I did not say that. I said I wanted to hear further from Mr. Brereton, and then I will come back to you.
Okay, but
you have not given me the opportunity to.
Mr. Brereton has already said that he intends to not interrupt the presentation of his case. He intends to continue. He said that already.
I have asked him to speak, and as far as I'm aware, I'm in charge of this courtroom.
Not capriciously, Your Honor. Only if you apply the law.
Well, Mr. Kuxel, you are being offensive.
No, I'm not.
And you are disrupting the courtroom.
I have a grievance, and will.
And I am ordering you to step outside the courtroom, so I can continue to hear from Mr. Brereton, and then I will hear from you as to the matters you say are urgent.
No, I'm not, if you're sorry. Also, Miss Zhu has started crying again. I do not want, can she be excused as well, because she's not well, and it's not.
Well, Mr. Kuxel, I will address Ms. Zhu in due course.
After he's presented his case.
No, I will. You haven't listened to me.
What's the difference between her and me? You wouldn't listen to me before he completes his case. Why would you listen to her?
How do you know what I am going to do? Are you a mind reader as well?
Because he has already said that he will complete the presentation of his case.
Well, as I've said to you, I am in charge of this courtroom, and I will direct Mr. Brereton as to how far I wish him to go, but he's mid-sentence. At least give him the dignity of finishing the sentence.
Okay, I'll give him the dignity of finishing the sentence.
Thank you. Just sit behind him.
Am I still ordered to go out or?
No. As long as you sit down and be quiet, you can stay there, until I have finished hearing from what I
can be quiet until he finishes his sentence. I can make that.
No, until I call upon you.
Okay, well, then I'm not. If you're changing your orders based on that assurance, I'm not making that assurance. I can only assure that I can be quiet until he finishes his statement, but if he intends to be abusive and violate the court.
No, Mr. Kuxel. Mr. Kuxel, that is enough. Enough. No longer am I going to put up with your abuse and your behavior in this courtroom.
Okay, well, then I'm not. If you're changing your orders based on that assurance, I'm not making that assurance. I can only assure that I can be quiet until he finishes his statement, but if he intends to be abusive and violate the court.
Enough.
Have you read the documents that have been sent there this morning, that we sent this morning? We've made our IBAC complaint against you for colluding with Justice Gorton. You had improper conversations outside the courtroom about me, about this process. There's documentary evidence of this. You made admissions yesterday. Mr. Brereton abused.
Mr. Kuxel, you are being offensive, abusive, and inappropriate.
I'm not being offensive. I'm being accusatory, Your Honor. I'm being accusatory.
And totally inappropriate. I'm gonna ask you to please sit down
I'll sit down until he finishes, yeah.
so I can hear further, Mr. Brereton, and then I will call upon you and Ms. Zhu to make whatever submission that you wish to make. Mr. Brereton, you were mid-sentence.
Thank you, Your Honor. I think what I was up to was I was saying that we in large part rest upon our written submission, and particularly the extent to which the three limbs upon which we say the fourth defendant should be successful in the proceeding or stand, and in fact, on my submission, are further fortified by the events that occurred yesterday. Certainly, the abuse of process limb has been significantly fortified by a range of things which, I should say, in the ordinary course of events, I had hoped that the transcript of yesterday might have been available so that I could take the court to some specific matters in relation to that.
It's not available?
Unfortunately, it hasn't.
That's why you orchestrated for him to make these accusations against me while I was not there. I did not get an opportunity to respond to those, Your Honor.
Mr. Kuxal, sit down.
Yep, no, I was noting it for the record. This is why he had done that, and you have cooperated with kicking me out.
Mr. Kuxal plainly is a person who abuses the court's process. He is doing it on so many.
Sorry, is he making a sorry, Your Honor? I object to that.
Mr. Kuxal. Mr. Kuxal.
I object to what he said.
You will get an opportunity to.
No, he is making allegations against me.
No, Mr. Kuxal. Leave the courtroom. Leave the courtroom. You are disrupting this process and I am unable.
He is making accusations against me without evidence.
I am unable to conduct the task that I have to do.
Your Honor, he just accused me of being a person who abuses the court process.
Leave. Leave the courtroom. Leave the courtroom, Mr. Kuxal, please. And please, stay within the hearing of the courtroom.
No, I'm not going to do that. You can kick me out, but you can't tell me where to go. That's imprisonment.
Mr. Kuxal.
It is imprisonment, if you confine.
I am asking you, Mr. Kuxal, please, I've asked you, or I am directing you to sit outside the courtroom.
I will not stay just outside the courtroom.
No. So I can call you back in.
I'm not going to do that because what you are doing is perpetrating an abuse through the transcript. Either I stay or I leave, or you're holding me as a prisoner.
Mr. Kuxal.
That's the law, Your Honor. You can't confine my mobility outside this courtroom except through imprisonment. If you are doing that, it is, in essence, imprisonment.
Mr. Kuxal, leave the courtroom.
Okay.
I understand you have access to the live stream.
No, I don't have any access to that.
Yes, you do.
No, I don't.
You were sent it yesterday.
No, I don't. I did not.
Yes, you were. You were given it yesterday.
No, I do not have access to it.
I'll just note for the transcript that sorry, Your Honor.
Thank you. Just the security people at the door. My understanding is, yesterday when you were all given the indication, the courtroom, the details I understand of the remote access was also sent.
Thank you, Your Honor. I was saying that in addition to the three limbs that we set out in our written submission that we rest upon, we also add to that judgment should be entered for my client, the fourth defendant, IBAC, on the basis that the proceeding should be dismissed for want of prosecution by the plaintiffs. As to the abuse of process limb, which is in the written submission and as things presently stand is proved, we say, by reference to the various transcript extracts which are included in the court book, which show the nefarious and inappropriate basis upon which this particular proceeding is being brought, we would seek to add to that the entirety of the events that happened yesterday in terms of all of the things that Mr. Kuxal talked about, particularly insofar as they concern what his intentions are in bringing this proceeding. As I said, I would have liked to have had the transcript, but his statements to the effect of bringing the proceeding for the purposes of, broadly, what he says is holding the government to account, or words to that effect. That's not the purpose of this proceeding. This proceeding is a very narrow question of whether or not there was jurisdictional error or error of law in respect of a decision that IBAC made in April of 2022. The same goes for, yes, I took a note of it, Your Honor. Mr. Kuxal was talking about his intention and why he was bringing the case. He referred to what he called a public scandal, and seeking to have the court hold the government to account. The same goes for Ms. Zhu's position. Now, as I mentioned earlier on today before Ms. Zhu attended and Mr. Kuxal arrived, she, of course, hasn't engaged in any of the entirely inappropriate behavior that Mr. Kuxal has. She's done her best to be respectful and to respond to Your Honor's questioning in a measured and appropriate way. She has also, I think, in fairness to her, gone out of her way to try and put her case as best she can. But in doing that, she has also set out late yesterday a series of statements which unequivocally establish the extent to which, for her too, this case is an abusive process. She talked about her desire to want to engage in a very broad-ranging inquiry in relation to all of the evidence that had been filed in this case to date. And she talked about wanting to do that, I think, for purposes which aren't related to the just, efficient and fair determination of the issues in this case, but, rather, for other purposes. Now, again, I don't have the transcript, but my memory is that it was along the lines of wanting to create content for something else that the plaintiffs are engaged in, insofar as the publication of their interactions with various government agencies and the court. That in and of itself constitutes further evidence of an abuse of process within the parameters of the test that we've set out in our written submission. It constitutes the court's process as being invoked for an illegitimate or collateral purpose. It also constitutes an attempt, and the only reason this hasn't arisen, I think, is because of the approach that we, as the defendants, have taken. But an attempt to use the court's procedures in a manner which is unjustifiably oppressive to a party. Of course, the fact that we've been sitting around this morning is another example of the court's procedures being used in a way which is unjustifiably oppressive to my client. And in addition to that evidence of the extent to which the court's procedures are being brought into, the court's procedures, are being used to bring the administration of justice into disrepute. And it's the important distinction I seek to make, Your Honor, because Ms. Zhu should not be penalized for Mr. Kuxel's, and I've used the word several times. Mr. Kuxel said before there's no evidence of his disgusting behavior. I, of course, say there is evidence of his disgusting behavior, and that evidence is not just the exchange that happened minutes ago, but the entirety of what happened yesterday. And it's the important distinction because without what Ms. Zhu had said about her intentions in this case, her desire to want to introduce a whole range of evidence and, essentially, conduct a royal commission through this lens, it might justifiably said that she is not engaged in an abusive process. But on my submission the court can't reach that conclusion given what happened yesterday. If I can further fortify that point about the extent to which, I'll withdraw that. Relatedly to that, of course there are issues of the extent to which there are the various chances that the plaintiffs have been given to put forward their case. And that's engaged of course, because in circumstances why I've now submitted or added, as a basis for why judgment should be entered for us, the case being dismissed, for a want of prosecution. I've taken the court I think twice yesterday to Karam v. Parman, which is referred to in our written submission. And the authoritative statement there by the Court of Appeal about the extent to which there's a limit to the leeway that self-represented litigants should be given. And it's at paragraph 36 of the Court of Appeal's judgment, a self-represented litigant cannot be allowed forever to stand behind the shield of his own ignorance, especially when it continues to subject other parties to costs and inconvenience, and add pointlessly to the load of the court's already limited resources. There comes a point at which a self-represented litigant must be required to take responsibility for his choices. Of course in the ordinary course, that is the statement that should be applied, perhaps one might say unequivocally, to a party that is truly a self-represented litigant. On my submission however, the situation's slightly different here and the court is entitled to treat the plaintiffs in this case, differently to your average self-represented litigant. A more accurate description of the plaintiffs in this case, is that they are professional self-represented litigants. The most cursory searcher-decided cases concerning the plaintiffs demonstrate that they are constantly engaged in litigation. Mr. Kuxel, he is not a lawyer, but he did spend quite a bit of time yesterday in his exchanges with Your Honor, talking about the amount of work that is done, the number of cases that he has memorized, etc. He's plainly somebody who is well read and clearly understands the issues that are at play. If he didn't understand the issues that are at play so well, he would not be able to engage in the type of conduct he is engaging in, and indeed wouldn't be in a position to be able to put the types of propositions that he has been putting to Your Honor most inappropriately throughout the course of yesterday and this morning. The same goes for Ms. Zhu. She's been an active participant in this proceeding. She has shown that she clearly understands what's going on. Her submissions yesterday were of a quality that suggests that she has spent a lot of time thinking about this particular case, a lot of time thinking about what her objectives are in being the second plaintiff. She knows full well that her objective is an abuse of process to the extent that it's not to have the question of whether IBAC's decision on the 5th of April 2022 was made in error of law or without jurisdiction. She knows full well that she's abusing the court's process to instead give herself, as is Mr. Kuxel, a forum to air a range of grievances, many of which have nothing to do with IBAC, but which are designed to provide her and Mr. Kuxel with content, material, whatever the case may be, for them to at some point presumably publish, rely upon, and perhaps even seek to advertise. There was some concern yesterday in the course of Ms. Zhu's submissions, about the extent to which she said she didn't understand what the purpose of the court book was, and she said that she thought that all of the evidence that had been filed in the proceeding to date would essentially go in for the purposes of the trial. I just want to spend a little bit of time unpacking that proposition, Your Honor, and I'll take Your Honor in a moment to the affidavit of service and the lengths we went to try and make it clear what was required. But before I do that, I actually want to say something about the proposition that all of the evidence that's been filed in this proceeding to date should be tendered or go in for the purposes of the trial, and demonstrate what absolute nonsense that is, and the extent to which Ms. Zhu knows it. If I step back from all of the things that have been said along the way, Mr. Kuxel, I think, seems to have a view that he disagrees with the decision that was made on the 5th of April 2022. He thinks it should have been investigated at that time, and he thinks that it should have been a public interest complaint. Because he disagrees with it, he thinks it must have been wrong, and he won't entertain any suggestion or any argument about that. But then if that's not enough, he goes the next step, it seems, and suggests that because in his mind it's wrong, that then also requires, or doesn't require, gives rise to other consequences, one of which is this constant issue, or not constant issue, but this issue that is brought up from time to time of misfeasance in public office. One aspect of the abuse that is being perpetrated, abuse of process by the court in this case, is what we've pointed to in the transcript extracts on P2 of our written submission. I don't need to take you to them specifically. But there Mr. Kuxel talks about what he describes as the conundrums that would arise if IBAC ultimately did what it's now done, that is to say assessed the later complaints that have come and considered on the balance of the totality of the material before it that it is appropriate to investigate the allegations and classify the matter as a public interest complaint. Now, I suspect the conundrum that he points to is that he thinks that that gives him the opportunity to have some other cause of action. And in fact, I think in one of the transcript extracts he talks about other causes of action, yes. Sorry, I should have had the specific pinpoint reference. The 9th of November 2023, transcript P99 lines 8 to 26, court book reference 14, I submitted a fresh application to IBAC. Now, the reason why I made the complaint was effectively to see whether IBAC would now action the matters in light of its very well-founded awareness of the issues. If it responds to my complaint and dismisses it, then they understand that I have another cause of action against them. If it responds and declares that it's a public interest complaint, then it means that it's conceding that it should lose. Doing the best we can, this whole issue of another cause of action and the constant reference to misfeasance in public office seems to suggest to me that Mr. Kuxel thinks that a consequence of this case would be, if he was to be successful, that is, that he would, as a matter of fact or logic or a combination of both, have a cause of action against perhaps the organization for whom I appear, or perhaps individuals associate with that or that are part of that organization. Of course, that's a nonsense, Your Honor, and it's a nonsense because, first of all, S91 of the Evidence Act, even if there was such a finding that there had been a jurisdictional error or error of law in this proceeding, would prevent that from being admitted in any future tort case. Second of all, it would be highly inappropriate for the court to entertain what is essentially an attempt to go behind what are the very well settled, strict and appropriate mechanisms which must be applied when it comes to the court considering the very serious and significant tortious claim that is misfeasance in public office. Now, I of course don't need to tell Your Honor about the extent to which in a tortious claim of that nature the specific pleading rules that exist in Order 13 about the extent to which matters such as malice, intent and so forth would need to be pleaded and pleaded with precision, would necessarily need to be applied before anything could even get to first base. And of course, the significant repository of authorities which exist in that area of the law show that the vast majority of cases in misfeasance in public office don't make it past the pleading stage because the evidence just doesn't exist. Now, it may well be that part of the abuse in this instances was attempting to achieve an outcome where something might be said, something might be done in the hope that it can or could fortify or place the plaintiffs in a position where that tortious claim could be made at some point in the future. And of course, on one level, that sounds far-fetched, a bridge too far, and it would be a submission which would be an odd submission for me to make if it weren't for the things that Mr. Kuxel has said in the course of this proceeding, including the transcript extract that I pointed to in terms of him specifically referring to other causes of action. But the point being that it's further evidence, we would say, of the extent to which this case is clearly being brought as an abuse of the court's processes.
I take it, Mr. Breton, you otherwise rely on the written submissions that you have made in the outline that you provided. Were there any matters in them that you wished me to particularly that you want to say anything further about?
No, I rest on the written submission.
Yes, certainly. Mr. Kuxel.
Yes, Your Honor, I'll note for the transcript that while I was outside, I was continuously followed by a member of the court services staff who stayed closely with me and he was very professional and did not do anything improper, but I was uncomfortable with that, and when I asked why he could not leave me, he said that the judge's associate had asked him to follow me around while I was outside. Same thing had happened yesterday. I told him that I wanted to report this exchange, that I recorded it, after asking him to repeat it. I consider this to be an infringement of my human rights. I consider it to be imprisonment, as I previously expressed, and I say that on the basis of extensive academic research. I also wish to say that I have prepared an affidavit that puts the matters that I had emailed Your Honor's associate about into evidence. I had contacted JP. I was going to remotely witness it in the next 10-15 minutes, but I can provide the affidavit without the particulars of Jurat and make an undertaking to provide the particulars later today.
So does that mean emailed or?
Yes, I'm just emailing it now. The content of the affidavit is identical to the document that was previously sent, but I am
Is this the email exchange this morning?
Yes, there were a number of documents attached to the email. I'm sending the affidavit through. In addition, I have advised Your Honor that this morning I have made a complaint to the IBAC against Your Honor. Unless Your Honor is of the view that the complaint is made with the deliberate intention of perverting the course of justice, I think it would be inconceivable for Your Honor to preside in the matter in which the IBAC, which has to assess our complaint against Your Honor, is a party. It is an insurmountable conflict of interest that I need one reasonable person to agree. I couldn't find one who would disagree with that. Then I'm just sending the affidavit to Your Honor's associate and including, so the first document that I sent had attached to it, the first email that I'd sent had attached to it, I believe 4 documents. If Your Honor can confirm you've received all 4 this morning.
I'm just checking. Is that the email sent at 10:24?
Yes, it had 4 attachments.
That's 10:24 a.m. this morning.
Yes.
And it has 4 attachments.
Now, I'm just going to refer to that as soon as I send this through. Can I get my hard drive, please? I also note that Ms. Zhu was constantly texting me while I was outside and advising me that she felt intimidated and there were a number of horrible things being said about me for which I should have been here to respond. She also expressed her dissatisfaction that I couldn't control my temper enough to not fall for Mr. Brereton goading me deliberately, for the record. And part of our outrage comes from the fact that Mr. Brereton is intimately aware of our medical issues, of the challenges we faced, and has previously expressed sympathy and also acceptance of the reasons why we had those issues. He's participated in mediation on behalf of the IBAC where a lot of those issues were discussed, and he has deliberately exploited what he understands to be certain aspects of my nature and my medical incapacity to get an improper advantage for IBAC. It's a matter of fact which a different court will decide at a later stage, but it's one other reason why evidence of what happened at the mediation will be relevant and admissible. So I've just sent the documents. Now, Your Honor, this morning the 4 documents that I had sent, the first one was a document called Petition Seeking the Imposement of a Mandatory Code of Ethics, which that is. In that document, much of that document is not strictly relevant to what the matters in this proceeding, except to the extent that it refers to on P9 of the numbered pages, but P11 of the PDF, under Section G, our personal experience of the court. So this petition was drafted by myself, Ms. Zhu and Mr. Ansel. Because the platform where it was being posted allows only one person to post it, Mr. Ansel posted it, but it was our collective allegations against His Honor. It displays an excerpt from correspondence that had been sent to His Honor's chambers. That correspondence or that excerpt is also included in the affidavit, so that's that, but what is not included in the affidavit document is the additional matter of what's raised in paragraph 45 of that document on P11, numbered P11, PDF P13. So to demonstrate, I'm reading from paragraph 45. To demonstrate the absurdity of Justice Gorton's assertion that an inference of improper conduct may not be readily drawn from His Honor's decisions in our cases, we employed the assistance of ChatGPT. This is relevant because all of this material had been sent to the IBAC back in October. They used this information. The specific judgments had been sent to the IBAC. What Justice Gorton had said, why it was improper in the context, they then used this information to basically further compromise my rights. This is why I was outraged yesterday. I saw.
What's the aim of these submissions that you're making to me?
Well, firstly, I do not know what has been said about me, but what I have been told is some horrible things have been said about me. I am contextualizing.
You had access to the...
No, I did not.
No. Don't you lie to me.
No, I did not. I did not attend the hearing is what I'm saying, and I do not want.
You sent an email.
Okay, I do not want to be tortured this is not a court proceeding. You don't gag a person. You charge them with contempt if they are obstructing or not listening to the court's decision. If you were acting legitimately, you'd charge me with contempt. You don't gag me. You don't make orders in the proceeding against me.
Well, you're making submissions, I'm not too sure about what, but...
So I'm clarifying that the submissions are about, I am making complaints about denial of procedural fairness in this proceeding.
And to what end?
Well, that's for you to decide if you were acting as a judge, ethically. I can simply...
That's pretty offensive, Mr. Kuksal.
That's the law, Your Honor.
It's pretty offensive to infer that I am not conducting my duties.
Your Honor, I've made an allegation to the IBAC. If I made it fruitlessly, it's a criminal offense. I've already made an allegation that you're...
But are you saying, Mr. Kuksal, what your submissions are at the moment is that you are actually making an oral application for me to recuse myself? Is that what you're doing?
No, I'm making...
Well, if that's the case, then all of those matters are peripheral. What you should be doing now is...
No, I'm saying I've had no opportunity to present my case and I wish to be heard. No, I cannot because I have not. I don't know what they said. I don't have the summons. They misrepresented to the court that the summons have been.
Mr. Kuksal, you have had the written submissions in the court book.
No, I haven't. No, you found yesterday that I hadn't. Sorry, Your Honor.
I have an affidavit which proves that.
Okay, you ask them. Sorry, can you not, please? Can you not interrupt me?
No.
No, you're changing from one fact to another. Yesterday you found that.
Mr. Kuksal.
That I had not seen the documents.
Mr. Kuksal.
Yesterday you found that I had not seen the documents.
Mr. Kuksal, please sit down. If you can't.
No, you're trying to create a false narrative and then you're trying to keep me from saying what I can say, so my appeal is compromised.
What I'm trying to do.
Let me speak though.
Is give you an opportunity to present your case.
Okay, give me a certain time, I'll use it however and what.
It's now.
Okay, that's fine. How long are you giving me?
You have the balance of today.
Okay, so let me speak as I want to and you can decide.
It has to be.
No, I'm utilizing my time.
This is not an opportunity for a.
Okay, what you're trying to do is suppress, Your Honor, you're trying to further pervert the course of justice.
If you're not prepared to address me on the substance of.
I'm making a fresh recusal application.
The originating motion, then I will take it that you have waived your right to do so.
Yeah, because you're acting corruptly. Because you're facilitating circumstances to deliberately, dishonestly decide the matter.
I'm giving Ms. Ju an opportunity to say what she might wish to say, and then we can complete this case.
Ms. Su doesn't have access to any of the evidence or the documents because she had relied on me too. I have those. Anyway.
Mr. Kuksal, do you wish to address me on the substance of the originating motion?
Yes. I say that I have produced an affidavit that has been provided to Your Honor. Based on the affidavit, the evidence in the affidavit or affidavit without the particulars of jurat, I have undertaken to provide the particulars of jurat later today. The affidavit alleges that Your Honor has, on evidence which I understand is admitted but Your Honor can correct me if I'm wrong, that Your Honor has had correspondence or communication with Justice Gorton, directly or indirectly, and on account of that correspondence or communication, Your Honor has been influenced in the manner in which Your Honor has exercised or purported to exercise her discretion. That is fundamentally incompatible with the exercise of judicial function. Today I have also provided Your Honor with a copy of submissions or applicable authorities, quotes from them, just now with the draft affidavit. And I read from the second paragraph. This is re JRL, ex parte of CJL. If a counsellor were given access to a judge to discuss privately a case pending in the court, the parties could have no confidence that justice would be done according to the impartial view of the judge on the evidence adduced in the proceedings. The parties to litigation are entitled to be present during the hearing of the case, not merely because they have an interest in the proceedings, but because confidence in the court could not be maintained if the parties are left unaware or only partially aware of the matters which affect the court's judgment. To leave the parties, typically anxious parties, to learn by report what has happened in their absence is to foster any apprehension either party may have that the proceeding may not be judicially conducted. Now, yesterday if Your Honor thought what I was doing was obstructing the progress of the proceedings, the appropriate course of action would have been to charge me with contempt, not to compromise or penalize me in respect of the matters of fact to be determined in the proceeding. Your Honor had no basis to conclude that I was not genuinely upset, and Your Honor made no such conclusion. At least I was not asked to address Your Honor in relation to that matter. There were a number of things said against Justice Brereton that Your Honor prevented me from referring to evidence in support of. I also note that Your Honor took objection to the reference to matters that were discussed in judicial mediation, which only the IBAC lawyers can take. It was not Your Honor's position to take an exception of privilege on behalf of the.
I am not prepared to hear material which I know is privileged.
You don't know that it's privileged. You will.
It's in mediation.
Yes, but there's a broad exception to mediation.
Mr. Kuksal, what exactly are you trying to...
No, I'm not going into what was discussed. What I'm saying is yesterday.
Mr. Kuksal, it's now 1 o'clock. I am going to adjourn for the luncheon adjournment. I know we've wasted a lot of this morning, and at 2 o'clock I'm going to return. I will hear you on the substance of your...
So you're continuing to preside over a matter in which IBAC was a party where a complaint against...
Absolutely.
Where a complaint against you has been made to the IBAC.
And I've given you an opportunity to present your material in relation to the substance of your originating motion.
No, you haven't. No, you haven't. You found yesterday that I had not seen the documents.
And you will...
You found.
This is your case to run.
Yet I am seeking an adjournment. You have to give reasons.
And I don't deny that.
On what basis? You've not given me any reasons for that.
And at 2 o'clock...
On what basis have you denied the adjournment? I need reasons for that.
We've heard yesterday.
What were? No, you never gave reasons for.
Give written reasons.
I didn't even know that the matter was on today.
You got an email last night, Mr. Cooksall.
Sorry, but you said the hearing would resume. It didn't say that the matter would be heard today. All it said was,
The trial started yesterday.
no, it did not. When I was last in court yesterday.
Trial started yesterday. It was listed for trial yesterday.
No, Your Honor, yesterday when I was in court.
Mr. Cooksall,
I did not know that the trial had started.
listen to me.
I'm trying to find for the transcript. I did not know.
No,
I did not know. I did not know that the trial had started.
you are not listening to me, and you are not taking an appropriate direction from me. I've just explained to you the trial started yesterday.
You've just now told me that for the first time.
What do you think you were doing here yesterday?
I was here for the summons. When I was last in court, the summons.
The trial was listed for yesterday.
Your Honor, I find your condescending expressions very improper. You know that when I was in court last, the only matter being discussed was the summons.
The matter was listed for trial and for application.
Okay.
There were two matters.
We were seeking an adjournment.
Yes, and it was refused.
No, only the adjournment in respect of the summons was refused.
No,
Well, Your Honor, I did not know that, and there was no clear indication.
and you had the opportunity to
No, I did not.
listen to the proceedings.
No, I did not.
We made those arrangements.
No, you had no authority to take me out.
You chose to ignore that opportunity.
No, you had no authority.
That is a matter for you.
That's a matter that a different court will decide. That's fine, but no. Your Honor, there's no point in this. The matter is clear.
Arrangements were made,
Can we leave now?
and you chose.
No, that's not. You kicked me out after I caught you lying, and I accused you of lying.
Because your behavior is totally unacceptable,
No, that's not true.
and your attitude is.
You lied. You're still not denying that you lied. I know that you're not denying that you lied. I know that you're not denying that you spoke with Justice Gorton.
I ask you to withdraw that allegation.
I'm not withdrawing that allegation.
Then that allegation is totally inappropriate.
So you charge me with contempt if you think it is contemptuous of the court.
We will adjourn for lunch, and we will return
You're not denying it.
at 2:15.
You're not denying it.
Your behavior, Mr. Cooksall, is utterly atrocious
Yes, and you're not denying it.
and totally unacceptable, and your allegation.
You're not denying that you did lie. You're not denying that you did speak with Justice Gorton.
We will return, if you wish,
Still not denying it.
at 2:15, and you will make submissions
Can you please deny it?
to me on the trial of the matter.
You're trying not to prejudice yourself for your own case.
You have the afternoon to complete this case.
Great. Can you advise me who else you've spoken to about this matter? I'll tell the court.
And if you do not wish to participate and make submissions
No, you are lying.
in relation to.
Your Honor, no, you can kick me out. No, I'm not going to let you make a completely facetious.
I am going to let you make.
Then kick me out. Kick me out.
Please sit down. Please sit down.
No, you kick me out.
Please sit down. Please sit down. Please sit down and be quiet.
I will not listen.
Please sit down and be quiet.
Okay, you're lying.
Please sit down and be quiet. Please sit down and be quiet.
This doesn't work, Your Honor.
Please sit down and be quiet.
You can kick me out if you want.
I'm now adjourning for lunch. All right, Mr. Cooksall and Members Xu, you have until 4:15 to make your submissions on the substantive originating motion.
Your Honor, I've just provided a copy of the affirmed affidavit.
Yes, I think that's been received.
Okay, so I wish to refer to it and...
Was there any change from the unaffirmed version?
Yes, nothing has been removed, but more things have been added. Additional things have been put there. In particular, the addition. So Section D has been added, which was not originally there. It's on pp 8 and 9. It basically speaks about the fact that Your Honor has improperly prevented us from producing evidence in relation to what we say is IBAC's improper use of information that was provided to it for the purposes of enabling it to assess our complaints and to address our grievances, and we allege that you're obviously not letting me rely on the evidence, so I'm not going to do that. Not that I agree that Your Honor's acting lawfully, but simply for the sake of maintaining decorum. But we say that the evidence, part of which has already been provided to the court through emails that were referred to, and those emails are exhibited. The emails were forwarded to the registry over the months and that Justice Guinane has already considered in this matter. So that evidence and other evidence that Your Honour's not letting us produce, we say provides a basis for purport to infer that the provocation for myself that took place yesterday was an improper tactic of which IBAC was aware in our submission, that I was particularly susceptible because I had raised complaints about those issues. Not just for mediation but otherwise as well. I'd provided documentary proof of how prosecutors acting for Victoria Police had exploited the post-traumatic stress disorder that I have and Ms. Zhu has, and our susceptibility to unwanted attacks. We react in different ways. I had personally discussed this matter as well with Mr. Brereton during the mediation, which is a different matter. And it's not in evidence for the sake of the court, on record I note, because Your Honour has not let me put it in evidence. I was concerned that if I swore another affidavit about that, Your Honour would not let me rely on it anyway. But I'm happy to give evidence right now from the witness box in relation to that. Also, it refers to the fact that the matters that have been put to Your Honour, not Your Honour per se but the court in submissions and other material that was filed by the IBAC even prior to Your Honour's involvement, which I was advised by the registry commenced around the 12th of November or thereabouts. That's when I was advised the case was allocated to Your Honour. So the submissions and material that the IBAC has filed with the court is in direct contradiction with some matters that have been raised in mediation and communication after that. We had sought to raise those matters in court. That was part of our case, which we are being prevented from doing. We have previously sent the emails timely before the expiration of the deadline, but Your Honour has repeatedly refused to hear me in relation to those emails. And it also notes that the IBAC had not privilege, and I had advised Your Honour yesterday that the communication which was provided to the court clarifies IBAC was copied in that correspondence clarifies that we had given IBAC the opportunity to apply for an injunction. We told them that 2 days later or some many days later we were going to provide this document to the court and we were giving them an opportunity to seek an injunction and that they should advise us if they need longer to apply for an injunction. We had then been advised that the IBAC did not intend to apply for an injunction. The document was then provided to the court. It was referred to in open court before Judicial Registrar McCann. Judicial Registrar McCann had also confirmed that she had gone through the correspondence, which contained details of what was discussed in mediation and matters raised subsequent to mediation, and the IBAC took no exception to it during the hearing. So that email correspondence is exhibited to the affidavit. It will be for the court to assess. Now, I'm going to quickly, if I could get just 30 seconds. Your Honour, could the court please advise me when the hearing before Judicial Registrar McCann was?
The 22nd of May.
Thank you. Okay, so Your Honour, I note on the 14th of May, Ms. Zhu had written to the Registry Judicial Review at subcourt.vic.gov.au and she had provided documents that directly discussed the mediation, our rejection of it, the basis and what the IBAC had said in response, and the fact that IBAC had sought to only settle the matter if we provided a waiver of any misfeasance claims against not just the IBAC but its officers, and that I had noted in response that this was blatantly improper because misfeasance is a personal tort and the person is individually responsible. And it was no different from embezzling funds from the IBAC or other improper conduct. That email, which was sent on the 14th of May at 6:57 p.m. by Ms. Zhu, said, "I write on behalf of the plaintiffs in the aforementioned proceeding. The plaintiffs seek to file, so many documents, and this is underlined in that email. Furthermore, the plaintiffs wish to rely on the attached correspondence from 10 and 13 May 2024 in relation to our allegations against the IBAC in relation to their abuse of court process and misfeasance in public office in dealing with our complaints." This was then referred to the Judicial Registrar McCann. Her Honour confirmed that she had read the material. Now, Your Honour was obviously not familiar with this yesterday, and you were not familiar with it because in my view you've not been diligent in discharging your duty, and in my view because you've not been interested in getting to the truth of the matter. In my view, Your Honour has improperly permitted the IBAC to use technicalities in a way that is impermissible under the law and under model conduct rules that are enforceable at common law, but also through the Victorian governments of the state's adoption of the model litigant obligations pursuant to the Legal Services Directions 2017 issued by the Attorney General, again pursuant to the Judiciary Act. Those pieces of legislation and regulations go so far as to say that even legal privilege that seeks to suppress evidence of improper conduct between the Executive and the Solicitor General's Office or the Australian Government's Solicitor's Office, even if those documents would have normally been privileged, privilege cannot be claimed if otherwise legally privileged material is capable of demonstrating improper conduct of officials. I say that just for sake of reference, that there are special exceptions that apply to government bodies concealing relevant information from the court where the people that are effectively benefiting from the privilege are not benefiting from it honestly or in the sincere discharge of their duty. So going back to that email also attached a bunch of documents besides the attachments through a Dropbox link. And then it said, we note that the attached correspondence includes matters, this is also underlined, that were covered during mediation, and the IBAC had originally objected to their disclosure on the grounds that the communication had been initiated on a without prejudice basis. So we have provided the court with the without prejudice communication that they have sent to us following the mediation, in which they had plainly said that we could not reach an agreement during mediation because you would not give us a waiver from claims of misfeasance against the IBAC and the IBAC's officers. Mr. Brereton chaired the mediation on behalf of the IBAC. Ms. Bridget Champerly was also present. She's I think present in court, instructing Mr. Brereton, and so was Ms. Chloe Armstrong of the IBAC. She wasn't there. Who was the third person? Sorry, Mr. Brereton just mumbled, and I'm not accusing him of heckling.
Chloe Armstrong wasn't there was all I'm saying.
I may have.
But I think the extent to which Chloe Armstrong wasn't there is an indication of was so far off the reservation, of relevance, but b, of the inappropriateness of.
That's not fact.
I'm just wondering, Mr. Kuxol, what part of the grounds of the originating motions do these submissions go to?
May I just address that? Because I have a right to address that. The fact that he's saying Ms. Chloe Armstrong was there or not there. Ms. Chloe Armstrong, no, I just want to address this for the record. Ms. Chloe Armstrong.
I'm just letting you know that you have till 4.15 to deal with.
I've heard you. You're taking time out of it. I've heard you.
Yes, and your attendance, late getting here, so.
I wasn't. I came here before you did, but anyway that's besides the point. Ms. Armstrong has not introduced herself to me. I associated I know Mr. Brereton has obviously introduced himself. I recognize Ms. Bridget Champerly from the meeting. I thought the person that was at the meeting was Ms. Armstrong, but if her name is different, that's fine. I'm aware of Ms. Armstrong because of the affidavits that she's filed, and I suspected that she had been participating on behalf of the IBAC. Anyway, to clarify that document that I was reading, it says, we note that the attached documents includes matters which were initially objected to. And then it says, however, following the plaintiff's communication to the IBAC explaining why privilege did not attach to the correspondence, it no longer seems to be pressing the point. See our attached correspondence to the IBAC today, the 14th of May 2024, seeking confirmation whether it was still objecting to the disclosure of the correspondence. Out of an abundance of caution, it is our view that the court ought to clarify with the IBAC if they wish to object to the production of the correspondence to the court before the court considers it. As I said, the documents were considered by Judicial Registrar McCann. Her Honor confirmed that she read the material that I had sent and that those were matters that will be relevant during the most of the proceeding, but I had relied on them in relation to making submissions about what directional orders should be made, and obviously Her Honor had used her knowledge of the contents of those documents in making those directions. I also note that further correspondence to the court was provided in relation to our communication with IBAC by me on the 15th of May, and then on the 17th of May more correspondence was provided. Now, in relation to the IBAC's knowledge of whether or not the charges against me were dismissed, I referred to the judgment of Justice Guinane. That was, I believe it was the 17th of May that the judgment was given this year, and it basically referred to the fact that we had advised the court that the charges had been brought and so on. Justice Guinane had referred to that. This matter was also discussed in mediation extensively, and the fact that the proceedings were to be reinstated, and again, that's all in there. It's also worth noting that the orders had specifically stated that the proceedings were to be stayed pending the determination of the charges as they were, not pending the determination of whether or not I had done anything improper ever. So the argument that maybe other charges may have been brought would not apply, because if new charges were brought against me, they wouldn't necessarily, or in fact they wouldn't at all in any conceivable circumstance, apply to an order that was made prior to the introduction of those charges, and an order that did not contemplate the bringing of additional charges. In any event, Mr. Brereton was required to be diligent before making submissions in opposition, or submissions that may impede an argument that I'm making or an interest that I have. The next matter is that in the documents that were provided to the court on the 17th of May, which are now exhibited to the affidavit as well, there were extensive submissions about, Your Honor, could you please open that document?
Which one?
The 17th of May email. It was sent to the court. I know that Your Honor personally checks the emails sent to the Judicial Review email address about this proceeding.
Tell me what it says.
The subject of the email is urgent. SECI 2022-04808 leave sought to file subpoenas and amended originating motion and affidavits, and that document has 4 attachments, and then there was a Dropbox link through which additional documents were shared. I referred to the second attachment there. Now, that document has extensive submissions about the manner in which the IBAC has acted negligently, so in breach of its obligations under the law. That would go to error of law and jurisdictional error. It sets up what the law is about, what it needs to do. So that document that I referred to, the second attachment to the email on page, starting from P4, it includes a letter that was sent to the IBAC, and it included firstly a transcript of the recording that was sent to the IBAC originally. The second document attached to it was an excerpts of the most dramatic components of that transcript, the parts where the police is openly talking about looting goods, they're ogling women that are my neighbors. They continuously refer to me as the Indian maggot. They express their resentment that they can't just lock Ms. Zhu up and beat her up so they can get her to give false evidence against me. One person asks if he can shoot me in the neck while they're transporting me to the station to my residence, and some other entertaining material. So those excerpts were attached to that letter, and they were provided to the court through the Dropbox link. Then it contains another document, a third document which is called IBAC transcript excerpts, which was again provided to the court. Now, those excerpts are the portions of the transcripts in this hearing that demonstrate the dishonesty of the counsel acting for IBAC. All the times they lied and then contradicted themselves or got caught. It then contains a copy of, it contains a document that consolidates recent news articles concerning issues of systemic police corruption that are central to our complaint. So the same thing that they did to us, that document contains news articles about them doing the same thing to other people. It also contains another document called Recent Government Reports, which, can I get water? By the way, these documents were also provided to Justice Ginane, and His Honor considered them. So at the end, essentially what Your Honor's basis for deciding matters punitively against us without giving us an opportunity to be properly heard is that we, in Your Honor's view, we didn't coordinate with the IBAC properly enough in the preparation of the court book, because all these documents are already with the court and with the IBAC. And also, the court has not given us an opportunity to be heard in relation to whether or not we did. We reject what the IBAC has proposed. The court has prevented us from filing evidence in relation to that. I can say from the bar table, just like Mr. Brereton did, that we did not cooperate in the preparation of the court book, that what he said is absolutely misrepresentative of the truth because of a number of reasons. I'm not aware that they have lodged any affidavit that sets out the evidence of us not cooperating in the preparation of the court book. I'm sure Your Honor will make an exception for them and draft an affidavit and ask them to affirm it promptly so an order could be made against us. I note that Your Honor had instructed and then given leave to them to file a notice of service of affidavit, a service of documents affidavit or summons affidavit, after I pointed out that no service of summons affidavit had been lodged, in circumstances where you've prevented us from lodging any new documents ourselves. I wasn't allowed to cross-examine anybody about the affidavit either. I would like to cross-examine them. I'm asking formally to cross-examine the deponent of that affidavit. Could you respond, Your Honor, about that request?
I'll ask Mr. Brereton. Do you have anything to say about that, Mr. Brereton?
We object, Your Honor. There is absolutely no basis upon which any cross-examination.
Your Honor, I don't want more time to be taken. He's objected. That's fine.
That's okay. No, I don't believe cross-examined on.
I had got that as soon he said, I object, and I knew what your answer was, so that's fine. So the next matter is it also contained a document called Recent Government Reports, which consolidated reports published by various government agencies concerning issues of systemic police corruption that are central to the plaintiff's complaints against Victoria Police. It contained a document and a video called Who Oversees Integrity of Victoria Police. I think that was a sarcastic compilation, but it purported that IBAC was responsible for the regulation of police conduct. There was a transcript of that conference attached to the letter, the conference on Who Oversees the Integrity of Victoria Police, that took place on the 17th of May 2023. Then it contained a copy of our first compromise offer to the IBAC to settle this matter, and it demonstrated, so they did not take exception about that. His Honor has already considered that letter, and essentially, not just in relation to costs but in relation to, when I say His Honor, I'm referring to Justice Ginane, but in relation to whether or not there was improper conduct. Now, the first compromise offer which was sent to the IBAC, so it was a series of exchanges between the 19th of June and the 22nd of June 2023. All we had said was that, they agreed to consider this matter. That's what we wanted from them, afresh properly. They refused to do that. So from there, in June 2023 we got to a point in May 2024 that they're now investigating the charges. I wanted to produce evidence about the course of the investigation or where the investigation is at. I could not have reduced it by the deadline that Judicial Registrar Baker had set because of the developments in that investigation, but that would have gone on to show that had the IBAC done its job and subpoenaed the documents from the police that they later did as part of the investigation, they would have discovered a number of things that corroborated our allegations. And what's important here is that since the time they dismissed our case in April 22 to the time that they finally did investigate it in 24, over 2 years later, those police officers continued to oppress us and take detrimental action against us. The proceeding in fact was only dropped after it was clear that the IBAC was going to take on the investigation following Justice Ginan's decision. But more importantly, those people would have been doing this to other people as well. Those corrupt officers for 2 years. And again, I say that as an allegation and not as a decided fact in the court, the fact that they're corrupt. But if it's worth investigating, it was worth investigating sooner. The second compromise offer, which was sent to the IBAC on the 6th of November, following another mediation sort of discussion between the plaintiffs and IBAC's counsel, then Ms. Granford. Because the matter has been referred to in open court and ultimately no objection was taken by IBAC in relation to mediation privilege, this is in the transcripts, but essentially IBAC had invited us to write to them with an amount to settle the matter. This was discussed in the transcript. Your Honor can hear their response. And this is the transcript of So-9 and the 10th of August 2024, Your Honor. These matters were raised before Justice Ginan. The excerpts from the transcripts were included in as attachments to the letters to which I refer and which are exhibited to this affidavit. So Your Honor will see what was discussed, what was not in those documents, if Your Honor reads them. Then there were a number of other correspondences in relation to the mediation which showed evidence of the IBAC acting dishonestly. Now, the letter to which I previously referred which we had sent to the IBAC, that is the letter to which these documents were attached. The letter was sent on the 13th of May 2024. It was sent to IBAC's legal counsel, Mr. Brereton. It was sent to John Fogarty, who's the instructing solicitor in this matter. Miss Bridget Champerley, I'm sorry if I'm pronouncing it wrong, your surname, and it was sent to Siobhan Kelly, who was a junior counsel assisting Mr. Brereton. It was sent to the Commissioner of IBAC, the Acting Chief Executive Officer, the Director of Assessment Review and Compliance, Director Assessment Review, Executive Director, Ms. Zhu. It was sent to Ms. Chloe Armstrong, Emily Ireland, Leah McKay, and Kimberly Attard. So those people had been sent that correspondence. So Mr. Brereton would have been familiar with the letter because, it would be professional negligence in my view for him not to read such a thing. But also I understand that his view is that the moment something is served on the person, they are taken to have read it. So by that token, these documents were provided. Now, it sets out firstly, that letter, the context to the correspondence, in which it says that we had made a number of complaints against IBAC's officers in relation to their failure to perform their duty, and that on account of that, there was a deep-rooted distrust that we had in relation to IBAC's intentions. And it accuses on evidence of the representative of IBAC of dishonesty in relation to contradictory matters that have been put to the court and in private correspondence. And then from Section B, it goes on to set out the legal principles that we rely on in relation to our case against the IBAC. Subsection B(1) is negligence. It quotes authorities, including Sutherland Shire Council v. Hayman, where it was set out what the criteria is for determining whether or not a party had acted negligently. Now, this is in the context of statutory negligence, so whether or not a government agency is performing their obligations under the law. I also note that because of the implications of authorities like Bardwaj, some Minister of Immigration, I'm just connecting to the internet, Your Honor. So the authority is, I'm having trouble connecting to the Minister for Immigration and Multicultural Affairs v. Bardwaj, and that's 2002, 209 CLR 597. Now, this authority has relevance in relation to the matters raised in the originating motion in a twofold manner, And this has been identified to IBAC in written correspondence, and we've asked them to clarify how it is that they're arguing what they're arguing. And this was, by the way, in May. I'm going to get the specific date. I'm sure we've provided it to the court, but I'll get to the legal principle first. So the first matter is that because of issues that were raised in the document that I provided to the court, they were raised more elaborately in the document that I provided to the court today at 10.40 or 10.24. It's called the proper exercise of judicial discretion. Now, what the IBAC has to do when they're assessing the complaint is also exercise judicial discretion. They're not exercising judicial authority, but they have to exercise the discretion in a judicial manner. It's at least analogous to the manner in which the decision has to be exercised. Bardwaj goes into detail about what the requirements are. In that particular case, the agency exercising the discretion was an executive agency, notably, so like IBAC. And essentially, what was discussed there were the basic requirements under the Constitution and under common law principles for it to be said that an agency, a government agency, had properly discharged their duty, and that if those requirements had not been met, it could not be said that the decision that they purport to have made is actually a lawful decision. So what happened in that case, Your Honor, is that essentially there was a person who had applied for, I'm just going to confirm. Okay, there was a person who had applied for an adjournment. A decision had been made in that matter, that person's application was not considered, and it came to the attention of the person who had made the decision, or the tribunal that had made the decision later, and the tribunal essentially reopened the matter to make a fresh decision, and then the government applied to the court and said that the tribunal had discharged its jurisdiction. It could not actually reopen the matter just like that. What the court found was that it hadn't actually discharged its jurisdiction because it hadn't been careful. It hadn't done what it was required to do under the law, and it's only when they act in accordance with the law can it be said that they had discharged their jurisdiction. So if the IBAC didn't do everything that they have done, then they have not discharged their obligations under the law. Now, that's a particularly problematic thing for them to argue that they have not done because they reversed their decision. And if it wasn't so egregiously improper, I think it's funny that they're arguing before Your Honor, effectively, a summary dismissal application again, saying that there is no evidence. 3 times they've lost that application before Justice Quigley.
3 times?
Yes, 3 times. It was first made in one way, then it was amended. The amended one was then, there was leave sought to file a fresh application after the amended one. It's all in the correspondence that you have, which was sent to you. I'm talking to Mr. Brereton. So to say that we haven't provided any evidence is blatantly absurd because the evidence is the audio recording, and I would like, by the way, it's on YouTube, they've been given the links, and the court's been given the links to the recordings, and I'm going to play the evidence which is with the court, just for clarity. How do I just play it on the speaker, Associate?
No, you're not playing that.
Why not? It's the evidence that we have filed.
Well, as far as I can see, it's not been filed, and it's not in the court book.
I can provide the date on which it was filed, and Justice Quigley has accepted that it's been filed. He referred to it in the decision.
I'm not allowing it.
What? On what basis?
Just get on with it.
Your Honor, it's in the court book, Ms. Zhu says. Yes, it's in the court book, Your Honor.
I can look at the link, and we're not going to waste time now.
No, but it's my time, I'm playing it.
Well, I wanted to raise with you, Ms. Zhu, did you?
No, sorry. No, Your Honor, why aren't you letting me play the recording? It's in the court book.
I'm about to ask Ms. Zhu how—
You're deflecting to a different topic because you're very uncomfortable. You look palpably uncomfortable. You're, in my view, looking for excuses to prevent me.
I'm just concerned about the time that we have.
Okay, but it's my time.
Yes, but what about Ms. Zhu's time? Is she not going to have an opportunity?
She actually asked me to play it.
Okay, well, I'm going to ask—
Yes.
Is she going to have an opportunity to make some submissions to me as well? Or are you going to leave that to Mr. Quigley?
Like I said yesterday, I did wish to play the audio recording that was given to IBAC. I said that can take some time, and that's recording, I believe, quite confidently, that once played to the court will understand why that we argue that the human rights are denied when IBAC decided to dismiss our complaints. And I want to say, importantly, is that human rights is not something that is too far-fetched or hard to reach. It's something that it's so basic and so minimum requirement that the government or the Australian government said that one can have, living in this land. So IBAC's position is that their decision is not a denial of our human rights. That's why they're still contesting this case. And we say that once the court, hearing all the outrageous things that the police said about me and Mr. Quigley, and I'm sure Your Honor will be—
No, don't be sure about that.
Outraged by what's being said in the audio recordings, just like how we react or how the court react to the other incidents, and I think—
She's referring to my alleged improper conduct, so she's making the subtle point.
It's fine, I will—
It's all right, I'll ask again. The question I actually put was given—
Are you okay with using your time for the playing of recording?
Yes, are you going to, given that we are going to 4.15?
Say yes, just say yes, don't waste more time.
Are you going to take some of that time between now and 4.15? Or are you going to allow Mr. Quigley to make the submissions? If so, we need to—
I think I would—
Just say yes, play the recording.
I do deserve to have extra time even if Mr. Quigley takes—
Well, we only have until 4.15 for the whole of the case.
Okay, on what basis? On what basis? Justice Quigley had said that the determination of the veracity of the recording is the way to decide this case. The recording is 4 hours. On what basis did you give us 2 hours to hear this matter?
Because this is not a merits review.
It's not, but
It is, but Justice Ginane has already found that if they ignored what was in the recording,
all it is, so you say that there's a recording, it has been.
they have not denied the legitimacy of the recording.
No, but so why do I need to hear it if.
Because if the recording is what it is, and this is what Justice Ginane found.
No, he didn't.
Okay, I'm going to read the paragraphs from His Honor's judgment.
no, sorry.
No, this is not.
No, let me just read. Don't stop me, Your Honor. You're raising the arguments to kill the time to prevent us from.
No. Well, I'm telling you, I am not going to sit for 4 hours and listen to a recording.
Okay, let me play the recording then. Don't take up more time.
No, I'm not going to sit here for 4 hours and listen to that recording.
Don't, okay, that's fine. I'm going to play clips of it.
If the recording is made available to me, then I can listen to it.
It is made available to you, it's in the.
And you can indicate to me which.
No, Your Honor, I want to play something.
No, I am making a direction.
Is there a reason why you won't let me rely on the evidence in court?
Because if you wish to put certain parts of it, then give me the timestamps and.
No, I want to play it in court. Why can I not play it? Why?
I'm not, well, because my view is it is not relevant to the issues that I have to.
Okay, that's fine, but I have to. You're sorry, I interrupted you.
And I've made a ruling on the evidence, and I'm not allowing it to be admitted.
Your view is what, sorry?
I'm making a ruling that this is not a hearing on the merits and it is unnecessary.
So the recording is not relevant.
It is not necessary for me to hear the recording. The fact that the recording exists and has been provided to IBAC is sufficient.
But how do you know what the content of the recording is?
It's irrelevant to me what the content is.
But Justice Ginane has said that.
Well, that might have been Justice Ginane, but I'm not Justice Ginane. I'm hearing the originating motion.
Well, it says that they've made a. Okay, don't interrupt me please, let me finish this submission. That the originating motion says that they made a jurisdictional error because they failed to consider what was in the recording in terms of its.
Where does it say that?
I'm going to refer to the originating motion. It referred to the case as well. I mean, it was done on the basis of what was done in Bear v. IBAC. Bear v. IBAC, they did actually consider the evidence, and I have a direct quote from a high court authority that dispels the misguided view that any examination of evidence is merits review. And I'll refer to it in a moment.
But show me where in the originating motion this is referred to.
Okay, sure, I'm just bringing it up. All right, so the originating motion, this is dated, I believe, the 26th of August.
No, it's the 20th of January.
The 20th of January 2024.
Okay, let me just bring. This is the revised one that was filed, is that right?
Amended originating motion for judicial review and declaratory relief and claims in relation to IBAC, the 20th of January 2024. That's what I understand I have before me.
Yes, that's fine.
Not all of the other matters that were to form part of the earlier.
That's fine, I'm bringing it up. Okay, I have that, the 20th of January 2024. So the first part is we claim that pursuant to S76 of the Constitution of, well, the Federal Constitution, the Judiciary Act, so on and so forth, that the court find that, determine and declare that IBAC committed a jurisdictional error or an error of law in dismissing the plaintiff's complaint on the 5th of April, grounds relied on. The objects of the Independent Broad-Based Anti-Corruption Commission which have been set out in the section in S8 of the Act.
Section 8, yes.
Okay, so let's go to S8. By the way, you're taking up time, which I'm happy to use. So it says that.
I'm trying to make it relevant.
Your Honor, I'm sure a different judge will decide against Your Honor, but that's fine. In dismissing the plaintiff's complaint on the 5th of April 2022, IBAC acted in a manner contrary to objects of the IBAC Act as set out in S8, obligations pursuant to S15, 58 and 59. The purpose of the Public Interest Disclosure Act, as specified in S1 of the Act, its obligations under S26 and 45 of the Public Interest Disclosure Act, and what is said in S38 of the Charter of Human Rights and Responsibilities. Now, I'm going to go through each of these sections and show that if they had examined the evidence properly, then those sections would not have been contravened. But because they did not, they contravened those sections. But I also want to quickly refer to this authority just on the point of Your Honor making the silly suggestion that the case has to be constrained by the originating motion the way it was, not that I'm arguing otherwise. This is Bank.
Mr. Kuksal, it's not a silly suggestion.
In my view it is silly.
Well, I'd ask you to.
To lie?
Again?
To lie. Are you asking me to lie?
You want to lie again?
Your Honor, this mudslinging between the bench and the bar, it's beneath the dignity of the court. And if you had real authority, you would charge me with contempt, not engage in this back and forth, which is really very petty. But anyway, in Bonk Commercial SA via Kill Holdings Limited 1990, HCA 11, what the court had found was that the originating motion is not what constrains the hearing or the determination of the matter, it's the evidence before the court. And so long as people want to raise, the originating motion is just an introductory document that introduces what the matter is about and so on and so forth. Ultimately, the court has to do justice and resolve all the controversies between the parties. This was also clarified in Waterboard v. Misconduct 1988, HCA 12. Then there's another authority, rather famous one, which we have referred, which we have invoked I think at least a few dozen times in these matters, and that speaks about, okay. So I'm going to first refer to P&C Cantarella Pty Limited vs Egg Marketing Board, New South Wales, 1973, 2 NSWLR 366. It sets out model litigant obligations and they have an obligation too. Model litigants have an obligation to assist the court in the determination of the truth, including through the adduction of evidence that is contrary to their case. In Yongjun Keen, that's YONGJUNQIN, v. the Minister for Immigration and Multicultural Affairs, 1997, 75 FCR 155. This is a full court of the federal court authority. What the court found was that it is not a court that allows the executive to gain a technical advantage and prevent unsophisticated litigants or in any way people that have been wronged by the government from getting justice just because they didn't argue their case properly. Ms. Zhu also told me that Mr. Brereton had referred to me as a professional self-represented litigant. There is no such thing. I'd be the last person who claims to be ignorant in respect of the legal matters involving the cases that I am conducting. I have better knowledge of it than most other people involved. But that does not diminish my limitations or my disadvantages. As has been noted abundantly, I do not present matters in the way the court is accustomed for those matters to be presented. I obviously am someone who takes things extremely personally. All of those things, by the way, were set out in Matsukatidu vs Yarra Valley Rangers Council by Justice Bell that self-represented litigants, even well-educated ones, do not have the legal training necessary to present their case effectively and concisely or to focus on relevant parts, or the fact that they're generally very emotional about the subject, and the sentiments make them make all sorts of mistakes. Then there's the personal pressure that they feel of the consequences arising from different matters and a number of other things. There are no professional self-represented litigants. Even lawyers in their own cases are. It's not advisable that they contest their own matters. Now, in Yongjun Keen v. the Minister for Immigration and Multicultural Affairs, I previously provided a citation. It's a full court of federal court authority. It was said that, so in that matter the wrong form of document was used to commence proceedings against the state, and the relief that was sought would not be sought through that means. By the time it was discovered and the application to have it dismissed was made, it was too late for the correct form of application to be made on account of statute of limitations. Okay, far more legitimate a basis for raising technicality than what IBAC has been doing in these proceedings. Anyway, what the court found was that it was, I'm going to use the exact phrase. Before dealing with the question raised, we are bound to say that we share Justice Hill's reaction that an injustice was involved as a result of the taking of the technical point by the Crown. That is more to be regretted when the point is taken by a party which is expected to act and to be seen to act as a model litigant. So they're preventing us from filing evidence. They lied about when they had served the summons. They had served it 1 week before. It's on affidavit today. The documents are voluminous, they are very technical. Even if they had been served on a lawyer 1 week is not sufficient. I had other commitments. I had not seen the documents. You found that, and we're not getting an adjournment. Well, you decided the matter yesterday, anyway. And I didn't know that this case was being heard until you told me this morning, so no preparation, and you're not giving me an adjournment. Anyway, what was said that it is worth recalling the observations of Chief Justice Griffith in Melbourne Steamship Company Limited. The citation is provided there. The point is a purely technical point of pleading, and I cannot refrain from expressing my surprise that it should be taken on behalf of the Crown. It used to be regarded as axiomatic that the Crown never takes technical points, even in civil proceedings. Definitely not in criminal proceedings. I am sometimes inclined to think that in some parts, not all, of the Commonwealth, the old-fashioned traditional and almost instinctive standard of fair play to be observed by the Crown in dealing with subjects, which I learned a very long time ago to regard as elementary, is either not known or thought out of date. I should be glad to think that I am mistaken. It may be said, then they refer to more authorities in support of that, and then they say, it may be said, however, that the present point is jurisdictional rather than a question merely concerned with practice and procedure. Like I said, the technical point there had more substance than all the flimsy arguments put by Mr. Brereton. The distinction is, of course, well recognized, the distinction where a jurisdictional argument is raised whereas another argument of technicality is raised. What the court meant by technicality in that particular context is not deciding the detailed facts of the matter and raising questions of law to obstruct, impede, circumvent the determinations of factual matters. That's all we've been asking the court to do. What the court said is there is a difference when that argument is based on the basis of jurisdiction and, when it is said that the court should exercise discretion in that way. And when it's discretion, it's completely indefensible. Anyway, then it was said in that authority that a court could not allow an executive to benefit from technicalities like that, a proper court. Now, S38 of the Charter of Human Rights and Responsibilities, which is referred to in the originating motion, says, conduct of public authorities. Subject to this section, it is unlawful for a public authority to act in a way incompatible with a human right or in making decision to fail to give proper consideration to a relevant human right and a number of other things. We're saying that if they had considered the content of the recording and applied that consideration, they could not have made that mistake. And I will quickly refer to the authority that I was wanting to raise, which I think addresses what I consider to be Your Honour's misapprehension of what a merits review is. So there's 4 authorities that I would like to cite. Minister for Immigration and Citizenship vs ZIAI, and the citation is 2009, HCA 39. And among other things, it was held by Chief Justice French, Justices Gummo, Hain, Crennan, Kiefel and Bell that a failure to make an obvious inquiry about a critical fact, the existence of which could be easily ascertained, is a jurisdictional error. And so in that case the tribunal had something in front of it. It was found that it had a duty to make some more inquiry about the evidence in order for the tribunal to properly discharge its duty. It goes much further than what we're saying that they don't even consider the evidence before it. And I simply find it a waste of time that I have to argue that where the court requires an assessment of evidence to determine jurisdictional facts, where the legislation requires that, the court will basically shy away from its responsibility to see whether or not the evidence establishes that. In the document that I've sent to the court this morning, which is an article that my organization has published, there is a mention that jurisdictional facts have objective and subjective elements, and it is by the way, that is exhibited to the affidavit this morning as well, the article. The objective element requires an objective assessment of the evidence to determine whether or not the matters can or cannot be determined in a way that is proposed. So Your Honour may rule against us, I'm sure, but we want to rely on the evidence and refer to the evidence and make submissions specifically about some of the parts of the recording so we can identify things to be raised. We cannot do it simply by pointing out what times things are at, because it will impede our ability to identify things about the tone, what the context is, what can be clearly heard, how the IBAC should have understood it to be taken. So there's a lot of nuanced matters that we would miss if you are not allowed to rely on the evidence. The IBAC has taken no objection to the use of that evidence. I'm not sure if Your Honour is also colluding with Victoria Police so as to take preemptive objections on their part, but I cannot see any legitimate basis for Your Honour to prevent me from relying on evidence that is already in court and in respect of which all formalities have been satisfied.
Don't want to interrupt but just for the transcript, had there ever been steps taken to suggest that those recordings should form part of the evidence coming before Your Honour, we would have objected, and we would have objected on the basis of relevance.
Isn't the point that all of the various information that's referred to in paragraph 80 of Justice Janane's decision, which was between the 25th of February and 7th of January, the 7th of February 2022, the 7th of February 2022, the whole of the material sent to IBAC, it's never been denied that that information, all of those matters, were sent?
Correct, Your Honour, with respect.
So yes, I accept they were sent to IBAC.
But do you accept the fact that it says what we say it says? That's what.
I don't have to decide that. It's not a merits review. All I have to decide, I look at what information was sent to IBAC that's been assumed.
I don't understand. We've wasted so much time. I only wanted to play a few minutes of recording. Why did you stop me?
Well, Miss Xu told me it was 4 hours.
No, she said she wanted to play the whole, and I said I will play some short clips. I'm only going to take a few minutes.
No, give me the timestamp.
Sorry, I've clarified. Let me play it for 5 minutes.
No.
Why not?
I've told you I don't believe it's relevant, because the information...
You don't believe it's...
Because the information that's before IBAC is set out in Justice Janane's decision. There's never been a denial that information wasn't before IBAC. What is contained in it for the sorts of reasons you want to play it? Tone, nuance and the like. That is not a fact that I have to take into account.
Yes, you have to, because what the recording shows is that those things were being said to our faces.
I don't have to take those into account. Those matters into account.
How can you consider whether or not they consider our human rights? So, Your Honor, if someone is called some extremely vulgar thing behind their back, it's offensive at one level. If that's said to them while they're handcuffed and being pushed because that's what the police can do.
But there's no independent action based on the Charter of Human Rights.
Yes, you have to consider that. Well, Your Honor, I feel like I'm lecturing you about the law, which is it's a level of condescension even I'm not comfortable with. The point is that we're saying that if they had identified, if they had paid attention to what is happening in the recording, they could not have missed that.
But that's what you're saying to me.
Yeah, okay, yes.
But you're saying that to me, and I accept that.
Okay.
I accept what you say to me about it.
But let me just complete the...
I don't have to listen to it. You're telling me that that's your submission, and that...
But it's not been written down anywhere. We were relying on the recording. It wasn't ever written down anywhere that while that was said, it was said to my face while I was handcuffed. That is clear from the recording. That's why the recording is in evidence.
It's not in evidence.
It isn't.
That's the thing. It's not in evidence before me.
Okay, so you're saying, firstly, let's just clarify this. You're saying that all the evidence filed in this proceeding is not evidence that we can rely on, and you're saying that
it's not filed in this proceeding, is...
This proceeding is 04808.
Yes, and the only proceeding that is...
This is absurd. We did not think of it like that. We didn't think that we...
Well, you're wrong. You're wrong. The matter, a proceeding against...
Well, then, we seek an adjournment because we were wrong, we were mistaken, or we had a misapprehension. Because what His Honor did is not start a new proceeding.
No, he stayed the other and allowed this one to proceed against IBAC.
Yes, but so the audio recording is obviously critical because it was referred to by Justice Ginane in relation to our case against the IBAC.
All it says is that was the material that was before that sent to IBAC.
No, but it was provided to the court as well.
But he doesn't refer to the content of it.
No, he does. He says the plaintiffs have provided this to the court. It has not been tested. But it has been provided to the court.
Where does he say that?
Okay, let me just bring up the judgment. Okay, paragraph 150, the plaintiffs.
150?
Yes, 150. Now, let me read the whole paragraph. The plaintiffs cannot seek to have this court review IBAC's decision on the merits. However, their grounds contained in the originating motion for challenging IBAC's decision when considered with their oral submission contains two claims that have a real prospect of success within S63 of the Civil Procedure Act. Firstly, they claim that the IBAC acted in a manner contrary to its obligations in the SS 26 and 45 in the PID Act. As previously stated, S26 requires IBAC to assess a disclosure to determine whether it is a public interest complaint. Section 45.1 provides that a person must not take detrimental action against another person in reprisal for a public interest disclosure. The plaintiffs' claims were based, in part, on the events of the 6th of January 22 when they contend they were unlawfully arrested, their residence unlawfully searched and property converted. Mr. Cooksall sent IBAC a transcript of the audio recording of some of those events recorded on their phone. Mr. Cooksall said that it captured police officers using extremely foul language and joking about whether he could be killed and whether Ms. Zhu could be beaten up whilst in custody. He said that the audio indicated that Victoria Police were speaking with representatives of Channel 9 and advising them in real time what they were doing. IBAC's reasons for finding that the plaintiff's complaint was not a public interest complaint arguably suggests that it did not take into account that detail. Now, this is just one aspect of the thing that His Honor has identified. You may not agree with him, as you've said, and you may find that something that he had not pointed out here but is captured in the recording, maybe they said something offensive about judges who don't do their jobs properly that you'll take an offense to. So you should be able to let us rely on the recording itself to see if, like His Honor, found some things that were problematic. This account is not exhaustive, obviously. You may find some other things that are problematic that His Honor has not included, and that will be particularly prejudicial to us in the event that you do not find these things as problematic as Justice Ginane finds them, or if you think that there's some other consideration that Justice Ginane has not taken into account. So I can't see how the evidence has been submitted in this proceeding. It's relevant prima facie because of what has been said in paragraph 150. And the authorities, by the way, that I had referred to one. The other really important one is SZFDE v. Minister for Immigration and Citizenship 2007, 232 CLR 189, and in that one it was, literally, said that an obvious exception to the scandalous argument that assessment of evidence merits review is the fiduciary fraud angle. So fiduciary fraud being different from common law fraud in the sense that the fiduciary had a responsibility to do something and they failed to discharge their duty properly. So whenever it is argued that a government agency did not properly consider the evidence, merits review is no longer relevant. The evidence merits review is no longer relevant. The argument that the evidence should not be considered because it would constitute a merits review, that argument is moved, is no longer forcible. So we should be able to play at least parts of the recording, so we will not, say, play the parts of the recording that His Honor has referred to there where it doesn't add anything more, but we should be able to play any new very problematic things. So it will assist in two ways. One, like I said, you may find the other things problematic and not the ones that Justice Ginane has referred as problematic. But secondly, you may also find that, maybe they can miss one or two things, but to miss so many is a particularly problematic thing.
I think in the interests of time it would be much more
It will have taken 5 minutes.
beneficial for me to look at that recording.
No, it will not, because we will argue for longer, and I think that is your intention. You're deliberately wasting my time. Let me play it.
Well, it's now 3:45, and I am—
Sorry, Your Honor. So do you maintain your position that it is not relevant?
I do. It's not material, which I believe—
Relevant, sorry. I don't understand material. Relevant is a defined term under S55 of the Evidence Act.
Well, Mr. Kuksal, I have—
Can you say relevant or not? I want.
No, Mr. Kuksal. Don't tell me what I should or shouldn't say.
I'm asking for reasons and I'm asking for a decision, as I'm entitled to. I'm asking for a specific.
I want the opportunity separately to look at the material to see if it's relevant.
I'm not going to stop you looking at it separately.
Thank you. Well, that's what I will do. Now, you can move on.
No, but I also want to refer to it.
No, I'm not letting it play in open court.
On what basis?
Because I am going to listen to it separately.
And why are you not letting me play it in court?
Because it is now 3:45, and this case will finish at 4:15.
Okay, let's say, you will not give us more time. We say that you are giving us inadequate time anyway. But anyway, you will not give us more time, but let us play it within that time.
I will access that recording and you'll have it.
Why will you not let me play it?
Because in the interests of time,
Time is not a question, because you're not giving us more time, and we know that, but we still want to play this.
Well, if you want to continue to waste your time in having this discussion when I'm trying to eke it—
Okay, can I play it, though?
No.
Why not?
Because I've already said that I will listen to it separately and determine whether he—
Okay, but I'm saying that I will not be there to raise some points about nuance issues in the recording.
Tell me what you say about the nuances.
How can I tell you without referring to the—
You're supposedly familiar with the material.
4 hours. No.
Tell me what sorts of nuances they are.
I'm not. I haven't memorized the timestamps in relation to 4 hours of.
I didn't say that, Mr. Kuksal. I just said that
So how do it's going to be much.
All you need to do is tell me.
By the way, it will be far more inefficient for me to not be able to rely when I'm referring to things that happened, because I'll have to describe a lot of different things. If you give me.
You've already made the major allegations, and you say—
No, I haven't made the major allegations. There are some allegations which are best.
Well, where do I find those allegations that you've actually made?
I can play them right now.
Well, no, because this is not the nature of this type of application.
And okay. All right. I'm not sure what this type of application is, but
I'm trying to move the proceedings along.
We all know what you're trying to do, Your Honor. Okay, Ms. Zhu has just raised that I should also refer to paragraphs 151, 152, 153, 154, well, everything from 1.
I have read it through from—
Well, Your Honor, I'm not very—
150 right through to—
147 to 147 to—
154.
147 to 158 is directly relevant to this matter.
Yes, and I've read that as well. 147.
To 161.
Through to the section on charter, which goes through to 157.
So 161 is relevant.
Well, that just relates to delay.
No.
Sorry?
161.
161, not 162, yes.
161, yeah. And 160, 159, 158. 160 literally contains the things that we are alleging.
Yes.
Okay, well, I note how I'm comfortable. Your Honor, if you have some coordination with other people involved in this matter, you should declare that, but know that you're not letting me play the evidence, and so I will say something else.
And I have said that I will review the whole of it.
Yeah, very reassuring, Your Honor.
I'm glad you think so.
See, this is really beneath the dignity of the bench. You're not supposed to engage in this sarcasm back and forth.
It's not sarcasm.
It is. It is.
I have made a direction and I said I will do it, and I'm glad that it makes.
This is petty. You didn't think that I actually meant that. I was being sarcastic.
Well, don't be sarcastic in my court, thank you.
This is not your court, by the way. This is, anyway, we're not going to. So what I was addressing earlier is that the documents that we have provided to the IBAC, by the way, we want more time. We're not going to waste time on it, but we say that the time that you allocated to us is, firstly, you never asked us how long we will need. You randomly allocated that. I think Justice Gorton may have advised you on the tactic too. You've still not denied.
Mr. Kuksal, that's an inappropriate comment to make.
No, please deny having spoken with him.
Mr. Kuksal, that is an inappropriate allegation to make.
It's not. I can refer to you authorities that will say that when these things are raised.
Mr. Kuksal, move on.
The judge has to clarify.
Move on.
The matter of fact.
Move on. Move on.
You're concealing the matter of fact.
Move on.
You're concealing the matter of fact.
Move on.
Now, you're concealing the matter of fact. I'm not letting you.
We can go on if you want to continue this, we will.
That's your tactic, I know, but that's fine. The recording will show what you were doing. Anyway.
As it will show your behavior over the last 2 days.
Yes, absolutely. I think what you're doing is disgraceful, and so I'm being critical of it.
And that will be recorded.
Absolutely.
And has been.
So, I go back to the letter to which I was referring earlier. This is from the 3rd of May, and in that letter, so I note that Mr. Brereton was yesterday talking about the fact that we had never clarified to them that we were making misfeasance claims and so on. Following a judicial mediation that he had presided over on behalf of the IBAC, which he has not denied as well, but it's a matter of fact, the correspondence that they sent to us about why the mediation could not be settled was that we had not agreed to waive the right in relation to any future misfeasance claims we may bring against IBAC and IBAC's officers for failure to perform their duty. Now, that's exhibited and that was provided to the court without any exception taken by them. Now, I refer to the same letter of the 3rd. It then goes on to talk about misfeasance in public office, what the applicable legal authorities are. Refers to Brett Cattle Company Pty Limited versus Minister for Agriculture. It refers to Odivji Estate. This is a very important authority. Odivji Estate v. Woodhouse, 2013, SIC 263 Seychelles rupees. It's cited by a number of Australian authorities. Basically, what had happened is that the Supreme Court of Canada found, that's their High Court I was going to say, but obviously everybody would know here, that a personal liability for misfeasance in public office arose for public officers from their failure to perform a duty where the law expressly necessitates its performance for the benefit or security of a specific class of persons and its non-performance causes detriment to an intended beneficiary. In that matter, the relevant Commissioner of Police had the purview that IBAC has in this case of regulating the integrity of police conduct. A claim was brought against the Commissioner in relation to misfeasance for their failure to investigate the alleged tortfeasors, and they did not investigate the matter thoroughly. And when the claim was brought, they brought a summary dismissal application which was granted, and the Supreme Court reversed it. And again, it was emphasized that the manner in which an application is contested should not be the primary consideration. I also refer in this respect to the following authorities which have been referred to repeatedly in the IBAC's presence. And this is about your Honour's denial of proper time to us. So, Hutchings v. Australian Securities and Investments Commission. Adjournment was denied. What was found was that where the adjournment would cause a prejudice, this is the only criteria. It's not whether or not the tardiness or the party that has been disadvantaged is implicated. Where there is a disadvantage to a party and no greater disadvantage to the other party, then the denial of adjournment is a denial of procedural fairness. It's a jurisdictional error. Same thing was said in, so the citation for that authority, I'm not sure if I gave it, but I'm going to mention right now, is 2017 FCA 858. Same thing was said in Minister for Immigration and Citizenship v. Lee, 2013, HCA 18. There, multiple opportunities had been given to an application before the tribunal to produce evidence. They failed to do so. They wanted more time. The tribunal refused. What the court found was that was wrong because the consideration was whether or not they would be able to get it, the evidence. All these authorities postdate the Civil Procedure Act and they concern matters of justice or matters that are important for the vindication of rights. Now, I also refer the court to the authority of Minister for Immigration and Citizen v. La, 2007, FCA 1318. That sets out the again unreasonableness in relation to properly examining evidence, which is a jurisdictional error. And not just the primary facts but the matters that underpin the primary facts. Then I refer the court to Wootton v State of Queensland, No. 5, so the first word is spelled as Wotton v State of Queensland, No. 5, 2016, FCA 1457. This is an authority about allegations that were made against Queensland police. More atrocious conduct against Aboriginals, but basically unlawful arrest and other things. And Justice Mortimer laid out what the considerations there are for whether or not the conduct demonstrates impropriety or the violation of human rights. And Her Honour extensively goes through the various documents that the court should get guidance from in relation to what is proper police conduct and so on and so forth. So we rely on that, obviously. We also rely on Minister for Immigration and Bardwidge that I previously referred to, so I said that our reliance is twofold. So one was the jurisdictional error arising from denial of procedural fairness. The second aspect is also very important, and it was put to the IBAC along with other authorities in support, but that aspect is this: the court found that if the decision had been properly made, the tribunal could not reopen it of its own volition. So the government had challenged it on the basis that the tribunal had no authority to reopen the matter after the jurisdiction had been discharged. So we've put to the IBAC, they've not denied it in front of Your Honour. I say it's an admitted fact, but we've also exhibited the correspondence in which we've raised these matters with the IBAC. We've put to them how they say they could simply reopen the matter without admitting a jurisdictional fact. Now, Your Honour, very, very important here is the distinction between error of law and jurisdictional error. What the court found was that if jurisdiction had been erroneously exercised, it had been consumed. You could not reopen it by yourself unless the legislation specifically allowed you. There's nothing in the IBAC Act which says that they're entitled to reopen decisions that they've already made. So it's spent only in cases of jurisdictional error and more specifically through the want of exercise of jurisdiction, not excess obviously. So the only way in which they can lawfully make reopen the matter is if they made a jurisdictional error in the first place. And in this respect, I also refer to an affidavit that Ms. Chloe Armstrong had affirmed, where she said quite ambiguously that the complaints that we had previously made were either not considered or this is an exhibit to the affidavit. I'll point out the specific paragraph. So affidavit of the 14th of March 24. This is also exhibited to our affidavit additionally because it was provided in correspondence. So the 14th of March 24 affidavit, and it refers to a bundle of documents, and in that bundle of documents I refer to page, okay. I also want to point out one other thing before I go through that. In the same affidavit, if Your Honour goes to P10 of the PDF, there's large page numbers at the bottom. This is the rejection of the dismissal rather, of the complaint that is being considered by the court, the 5th of April 22 letter. It says there that, thank you for taking the time to submit your complaint. I refer to your complaint received on the 19th of January 22. Further information: emails received by IBAC between the 25th of January 22 and the 7th of February 22 and all audio filed provided by you using a link. That's what was referred to there. Thank you for taking the time to submit your complaint and please accept my sincere apologies for the time it has taken to assess and write to you in relation to your complaint. And then it basically says later in the document, under the heading, decision about whether the complaint is a public interest complaint, in the second paragraph, in this instance, IBAC determined that the matter is not a public interest complaint. The decision was made after consideration of the information provided. So this was a misrepresentative statement if not dishonest, because the person did not actually check whether the material was considered. Now, if that is just policy that this person, Suka Powerlikos, who we've been emailing with all the documents directly personally and who's the Director of Assessment and Review, if she just rubber stamped someone else's thing, that's a policy problem, but she said that those things had been considered. She certified that. Now, I then refer to the letter that IBAC sent to us on the 17th of May, which is also in evidence, through which they confirmed that they would actually investigate the matter, and it was referred to before Judicial Registrar McCann, the contents of that letter. In that letter, they apologized to us. No. In that letter, which is the why? Why are you saying that?
It's the 13th of May that.
It's the 17th of May letter.
The 17th of May. Sorry,
Your Honor. Ms. Zhu is saying something about an order made about not reading it out. This is the 17th of May letter. Or the 16th of May is the date on it. It was sent to me on the 17th of May. This one, it is, I'm not, no one has advised me.
What's the date of it?
It's the 16th of May, and it says, I refer to your complaint received on the 19th of January 22 and subsequent supporting information you have provided to IBAC. In brief, that complaint relates to allegations regarding Victoria Police's police officers' conduct on the 6th of January 22 and subsequent conduct of Victoria Police officers directly related to the events of that day. As you're aware, IBAC has been reassessing this complaint. Please accept my sincere apologies for the significant time it has taken to reassess and respond to your complaint. IBAC has thoroughly considered your complaint and supporting information, including additional information provided in April 2024 in relation to this complaint. And then it reverts to something else, and then, after careful consideration, IBAC has decided it will investigate your complaint. So that is different from saying, after consideration, we're not doing this, and then this letter says, we are sorry. After careful consideration, we are doing it. If this is not an admission, I don't know if they had to send me a vital organ with this letter by means of apologizing. So what is happening here is the perpetration of fraud, and I will deal with that at a different forum, but essentially they know what they've done. They have not provided any reasons for why they had reopened the matter or the legal basis upon which they can even argue that. And this was explicitly put to them, and reasons were sought from them in an email that was sent to them, I will confirm. So there's a lot of material in the exhibits, so I'm just identifying which specific one it is. So there was correspondence sent to IBAC between the 21st of June 2024 and that's when it starts, and then it goes on for a few days. I'm just opening the relevant letter. In that correspondence, for the court's benefit, we had referred to Padwalt and we had referred to Carson v. Legal Services Commissioner and other authorities, which, basically, state that if a decision is made in denial of the natural justice, then it's in jurisdictional error. And that if the decision is made properly, then there is no basis to revisit that. So this is Carson v. Legal Services Commissioner and Anna. 2000 NSWCA 308. So, effectively, we have an admission, and what we have is the IBAC basically reversing its decision without advising the court or us the legal basis upon which they can revisit their complaint. And it's worth remembering that on the 4th of August, this is also stated in Ms. Armstrong's affidavit, I had filed a fresh complaint about the same incident to get them out of their dilemma so they could investigate it. I had done that to give them jurisdiction to investigate the issue. Why would they take one? And again, it's worth remembering that the problem that this causes is that being aware of both the 4th of August complaint and the 10th of January complaint, when they open the investigation on the basis of the 10th of January complaint, they must have concluded that in relation to those offences no new information, no new evidence has been provided that will relevantly help them. Otherwise, why would they use that complaint and not the new complaint? So it cannot be on the basis of new evidence that we provided that they decided to investigate the matter, because that would just be legally absurd. They would then have to use the new complaint. So the investigation was reopened only the basis of everything that had been provided up until the dismissal of the complaint, the 5th of April 2022, because that was in support of the complaint. That's the only legally sound way of seeing this. Now, they've been repeatedly harping on about what's the point of this proceeding, so on and so forth. Well, I don't know what we're supposed to do. Either they apply, we offered to them that they should apply and accept that they've lost, or the court says that we've won. We cannot make a declaration that we've won. I've tried it several times. But it's ineffective in terms of resolving this matter. So it's absurd to say that we're committing an abuse of process because they've not filed a concession formally to admit defeat. And what they are trying to do is see which judge will bite at scandalous allegations about, the umbrage that I take at the corrupt conduct of public officers and so on. But that is not the relevant issue here. The relevant issue is that they didn't do their job. They lost. They reversed their position after they were sued, and they don't want to have the court say that they lost. If they wanted to save the court's time, they should have just said that they've lost. Then it would have been on us about whether or not we were raising new matters. But if they had just written to the court and said that, in the absence of us having raised any new matters that have been accepted, we couldn't have done anything. And even now, they didn't come and say, we say that we've made a mistake. If it is just this, then let's just solve it. Then it would have been on whether or not there's a Civil Procedure Act breach and so on. We would have had to make any applications. If we didn't make them properly, again, we would have lost. But it's just absurd to say that we're not doing anything when we've argued our case, we've won our case. He said yesterday, I'm told, that we got what we were here for, which is the determination of the complaint. It's absurd to say we lost because we came here for that exactly. And only by coming here did we get that. How could we have lost? We were willing to settle for less. We came here, we got more than what we wanted. We got exactly what we said that they had not done. Then, they did it. That's the purpose, that was the main purpose of this proceeding. In fact, we could not have even asked the court to ask them to do what they are now doing. All we could have asked the court was to say that, please, have a look at this again because you didn't look at it properly. And then hope that when they looked at it properly they would have done this. What happened is I told them that when the court makes a decision, I will publicize it everywhere and they will have a barrage of more proceedings. So they made the decision. All of this is, by the way, exhibited to the email. Sorry, to the affidavit because it was sent to the court previously. So what they did is they tried to stop the court from giving judgment. At the time, obviously, you were not involved, so there was concern that a judge may actually make some proper findings. So they, basically, reversed that, and then they first tried to work us by threatening us with legal costs or attempting to bribe us improperly. And, ultimately, when none of that worked, they're trying new tactics. But the plain fact is that they made a mistake. They've reversed their position. And now, instead of coming to the court and filing a letter of concession or admission of sorts, they're now wasting the court's time and engaging in deliberately disruptive and provocative tactics that they know through intimate knowledge of my health affairs and a number of other things, which has been improperly obtained because it was not obtained for this purpose. They're trying to, essentially, get the court to prevent their mistake from being ruled upon formally in a way that other people can benefit from this authority. We would not have been here and would not have succeeded if Bear v. IBAC had not been decided properly. It's a fact. Now, if this one is not decided properly, there will be a number of other things that will go wrong, and that, they're not concerned with that. What they're concerned with is losing another case. I know you've not given us more time, so I emphasize that we have not presented our case properly or been given an adequate opportunity. But I will spare people the spectacle of a shouting contest. And if you're not giving us more time.
Mr. Quigley, you make a good point at the end. It's just a difficult route for us to get there, so...
It's because I care about the route.
Yes. But anyway, it's now 4:20, and I said that you would have to 4.15. Now, I am not sure what arrangements you have made between yourself and Mrs. Zhu about...
We have had no conversations. She's been crying the whole day and it has not been possible to have any discussion in respect of the case.
Know that, Ms. Zhu, you heard what I said at the outset of this afternoon or before lunch, that we would hear the submissions in relation to the amended originating motion. You have heard what Mr. Quigley has had to say, and I also heard you yesterday in terms of the human rights aspect that you rely upon. I am assuming you adopt, in substance, the things that he has said. Is there anything additional that he hasn't already said that you wanted to bring to my attention?
Yes. So I will just, I think, take 10 minutes if that's okay.
Thank you.
But not because that's all you need.
No. I am prepared to sit to 4.30, so that we can hear that what additional matters you have got. Obviously, repeating what has been said before, I accept that you adopt those submissions.
Yes.
Also, I clarify, it's not that she only needs 10 minutes, but she thinks that you will only give her that much, so...
Thanks.
Yeah, so first I want to address the parts that Counsel has raised in this morning about yesterday what I have said about the using of the material. I deny what he said, that I have said that the purpose of me raising questions about whether or not we can use the materials for the publication. I just had concern. Or if we do wish to publish any content.
I've already published.
That's in those materials, would there be a suppression order threat? I was only concerned, but I have never said that the purpose of that, or engaging in this proceeding, is to create content. That's, I think what was said very hurtful.
Just take a deep breathe.
And that part about the professional self-represented litigant part, yeah. My point is that I don't choose to be a litigant in those court proceedings. What we had complained about the police misconduct, it had happened. I didn't ask for it. It happened because of some obviously past issues that I really have I didn't do anything wrong about. But the reason, just because we have chosen to sue the state or IBAC, for what we say is doing the wrong thing or making the wrong decisions, doesn't mean that I am a professional self-represented litigant. That indicates that I am suing for an improper purpose, and again, the reason, and it's only because we had brought the case on, and it's not the easy decision. The point I want to make is that we did not choose to be self-represented. Obviously there were issues that concerning the Legal Services Board. That's other story. But there was no intention to come to court or create a character of ourselves or to discover material or do anything just for the publication of, I'm not in the show business or anything like that. So I just want to deny those part of the allegations. And then I understand that the time has passed, so we are reviewing the decision that was made, the April 2022 decisions. So for two of the decisions that they have made that we are reviewing, one is that they're not investigating the complaint, and the second one is that they say it is not a public interest complaint. So I want the court to have regards to the S9 of the PID Act. That section had described what can be what is a public interest complaint? And I say Your Honor has to hear the recordings or know the content what's in there.
So can I confirm we can send you a link to the recordings?
So Your Honor can first have an understanding on whether or not it can fall into the category of the sealingness 9 of the PID Act. And then again, yesterday I also said something that I think can be a problem, so I want to clarify that. So yesterday I said that now we want less protections, given that everything is already in the public. But at the time when we were making the complaint, obviously we wanted to be a public interest disclosure and public interest complaint, because we would like those protections. But they did not classify as a public interest complaint. So that decision had taken some rights away from us. And those rights, if taken from us, can affect the human rights perspective. And again, I think in Justice Janane's decision, those sections, JES 26 and 27 of the PID Act, parts were already discussed in that judgment. So I will not go through the individual sections, but I would want Your Honors to obviously go through the details of those. And also obviously listen to the transcripts, and also the recording. So yesterday, even though I said that, now after 3 years of us making the complaint, we would want less of the protection. But it does not mean that when we were making the complaint in January 2022, we do not want that protection or the rights that were given to us, if those complaints were classified as public interest complaint. So I just want to clarify that, and I don't want them to say that's yesterday, because I said that, it's already in the open, so protection is not that important anymore. And then with the one of prosecution parts, I do want to say that we have been engaging with IBAC, because previously I was trying to see if we can settle the case, and after the second or the new decision was made, then we tried to obviously submit to the court. But again, that's a point that Mr. Cooksall already made, but we want to. Before Judicial Registrar McCann, we told her that we want to use that to help us, but they said, no, you can't use that decision as an admission of sorts. So they had tried to stop us from doing that, so it was not that the situation was not that we were trying to continuously abusing the court's process or wasting court's time. We do want to have it settled quickly, and we have engaged in the effort to, have it done without the court process, and again, I'm trying not to blame anyone, but it didn't work out. But if you can't say that, we are the story that counsel tries to present in the morning sound like that we are here to create a story, and then to engage IBAC so we can publish it, and that is the proper purpose, but that's so wrong, because obviously the reason why we came here in the first place was because we say that they did not investigate. They said they will not investigate the police conduct that we complained, and then they did not say it is the public interest complaint. That was our first and the original, or the purpose of why we are taking them to court, because we want them to investigate. And that is it, and that's what I said yesterday. If everybody is happy to have that concession recorded, then I'm happy with that. So, and again, I would just hope that Your Honor will also just go through the Bear v. IBAC case, as again, what I have said is that the human rights perspective is something that's not like public interest, that is so high and noble and, it's not a high bar to reach. So when the government authority makes decisions, if they fail to consider the human rights perspective, then it is said that in S38 of the Charter it's unlawful to not consider that. And again, because the human rights perspective are so minimal, they're minimal requirement for a person to have dignity and stuff, so I would say that it would not present to the court to having to reach a very high bar to have concluded that the human rights were denied. And again, if Your Honor can go through the transcript and the original complaint that we had given to IBAC, I think it would help the court to understand the case better.
Your Honor, I just want to raise a couple of issues quickly. The first thing is that because, as Your Honor has noted, I've been here, now it's 4.34. We've not been able to file the affidavit in support of the recusal application which has been provided to Your Honor much before 4 o'clock, so I seek an extension for the filing of that affidavit that's been provided to you via request.
You haven't been able to do it this afternoon.
Because I was here. Yes, can you give us until 10 a.m. tomorrow morning to file the document?
It's Saturday.
Okay, Monday morning.
Why can't it just be filed? Is it not possible to file after?
No, because your orders said what they said, and the registry may.
Okay, yes. I assume that you could file.
We can file, yes.
Yes.
But you need to extend the orders, and if you do it.
It's 5.30. I'll send you 5.30.
Your Honor, the law is that if your order falls in a non-working time, it automatically extends to
the Monday morning.
Yes.
Why can't you file it this afternoon? I can make an extension to a period of time outside of, what was the time?
Yeah, I'm just saying that it's irregular, but I'm not going to act. I'm asking you to allow me to file the same affidavit. I'm not asking.
Then file it when you can today.
Yes.
And I would like it done by 5.30.
I can't say 5.
It's in the next hour. If you've got it on your machine then.
Yes, okay, all right, I will.
I'll extend the time until 5:30 p.m. today, midday.
Could you give me until 6.30 at least?
Okay, 6.30.
Thank you. Okay, so that's one matter, cause I don't know how long I will be right now. The next matter is that I can swear an oath and go into the witness box, but I have no idea what happened in the proceedings when I was not there, except for what Ms. Zhu has told me, and she told me very little because of her mental state. And I didn't even know that he had accused me or us of creating content and all of that nonsense before she just raised it. So I don't know how many other matters are there like that, but I'm getting it for the record that whatever I'm not responding to, which was said in my absence, it is only because I have no idea about what was said. And I know that the court can see who is locked into the meeting, and the court is aware that I'm not locked in, that I wasn't locked into the meeting. So that's one matter. The second matter is that I want to just refer to the part of the transcript of the 22nd of May. This is before Judicial Registrar McCann, so there can be no argument about what had happened. Now, it's a court record, so I can rely on it without it formally being adduced in evidence. That's part of the Quigley J. Just tell me what it is, Mr. Cooksall. Mr. Cooksall, yeah, but I have also provided the excerpts, by the way, in the affidavit because it was sent to them. So this is part of so there's a document called IBAC transcript excerpts which will be included in the exhibit, part of the exhibit bundle, and what I've done in that document is essentially taken the excerpts from each day of the hearing and given them titles to summarize what I say happened during that discussion. So the last part of that, the last segment of that document covers the hearing of the 22nd of May 24, and it contains 3 subheadings. The first is, the IBAC has admitted its faults, and that quotes the part of the transcript where I put to Judicial Registrar McCann. Now, Your Honor, in terms of our position in respect of this matter, what we'd like the court to know is that the IBAC has taken steps since March this year, which gives rise to further claims against the IBAC officers. Okay, and then I refer to the matters that happened in the mediation. Not going to repeat them, cause I've said this today. Now, what we say, given that the IBAC has now accepted that the complaint was in fact a public interest complaint, and it has also accepted that the complaint should have been investigated and that it will now investigate the complaint, this was also referred to in Justice Ginan's decision, is what I say there, on the 17th of May. So the previous complaints that we were making against the IBAC, it is not in a position to defend them anymore because we have succeeded through its own admission in relation to those claims. Then the counsel, Ms. Kelly, had appeared on the day. She said, can I say 2 things about that? I didn't read everything that I'd said for the interests of time, so if Your Honor reads the document, the excerpts document, that'll be helpful. But she says, one is to pick up something Mr. Cooksall said about the IBAC being in a position to defend the proceeding by its own admission. This is contested, she says. Judicial Registrar McCann says, yes. And then she says this, and this provides some explanation of why she says it's contested. That a later decision has been made says nothing about the lawfulness of an earlier decision. More importantly, for today's purposes, and then she says, it's not to be discussed today. Now, Ms. Siobhan said that the IBAC had said that we can't use the letter as admission. She misspoke, because what had in fact happened is that she had said without knowing about the letter that the IBAC is not making any admission just on account of the fact that it has plainly reversed its decision. After what she said, I say this. The other matter, if I could quickly address something that Ms. Kelly has said. This is about the admission that I said the IBAC had made about its failure to properly process the complaint in the first instance. The new notification that I received from IBAC actually contains an apology for the error in the manner in which the complaint was previously processed, and in fact I haven't even asked them to reopen it. I have made a fresh complaint, and instead of processing that fresh complaint, the Deputy Chief Commissioner of IBAC, Mr. Stephen Farrow, wrote to me and apologized for getting the complaint wrong in the first instance. Judicial Registrar McCann, yes. The second thing is the court has supervisory jurisdiction anyway, so the court can review any of the decisions that the IBAC has made and so on. Then Ms. Siobhan did not say anything in response. So she did not actually, when she said that it's not an admission, it wasn't that she was referring to the specific letter. I don't even know whether she has a copy of that letter, because it's a letter from the Deputy Commissioner that goes on to the complainants. It's not part of this proceeding, but I had made it part of this proceeding by giving it to the court, and Judicial Registrar McCann had read that letter and all the other material that is referred to. Now, Your Honor, it would be very hard to say that part of the proceeding, which commenced after His Honor Justice Ginan had made the orders, by that time, the proceedings had been extricated. So at least what was before Judicial Registrar McCann, what the court has already considered, is documentary evidence in this proceeding, if it is relevant. So that was what I wanted to raise. And then finally, I confirm that Your Honor has given us leave to provide a link with the portions of the audio recording that are useful. And we can give the whole recording as well, but it will save you at least several hours if we give you the portions.
What you want to rely on, yes. I am agreeing to receive that material on the basis that I will rule as to its relevance and how it might be used. Now, I know I haven't heard you in relation to it, and I will give you that opportunity.
Well, it's difficult to make meaningful submissions in the abstract, Your Honor. I think the position surely must be that it's received on the basis that Your Honor has indicated, noting that it is the subject of a relevance objection. I think in the usual course, Your Honor would actually need to make your own assessment of the material before you could make a determination as to whether or not the relevance objection should be upheld or not.
Yes.
So in those circumstances, I think the appropriate way to handle it would be for Your Honor to perhaps listen to the recordings and note that that is occurring in the context of our objection, and then, after you've heard the recordings, make an assessment of whether or not the objection is capable of being sustained or not.
Yes. What you send to my chambers, Mr. Cooksall, also you need to send to…
Always, Your Honor. I don't.
Just so that we're also on the same…
Can I just say, in relation to those things, though, Your Honor, we would seek that they're not YouTube links or links to YouTube pages. They should be self-contained files which are downloaded to the local system on which they are being listened to. There are issues with YouTube, in the sense that, and Mr. Cooksall, I suspect, is aware of this, when links to YouTube are sent in particular ways, people can view who has viewed things, when they've been viewed, the details of the computers associated with when they've been viewed, etc.
Is it possible to put it on a USB?
That would be a much more appropriate way to.
Yes.
I can provide it to your Dropbox.
I don't know that I can access that. We have got quite complicated.
Well, Justice Gorton used it.
He's much more technologically capable. My preference would be if it could be put onto a USB and then it's self-contained, and I think that's better.
And how would I?
If you just bring it to the registry.
Okay.
Deliver it to the registry.
I may have a USB now. I can maybe, if it'll take me 10 or 15 minutes to download it. I can give it to your associate after the hearing.
I'm not intending to detain them much longer this evening, but I think the easiest thing would be if you put it onto a USB and you forward it to the Prothonotari's office or the registry.
Yep.
And then it can be forwarded to me. I think that's the most appropriate course.
Thank you.
Thank you. Now, I know I haven't thanked you. I will deal with all of the matters that have been raised, both as interlocutory or other, in the course of dealing with the matter as a whole, and if anything arises once I receive the USB, I will inform the parties and we can take it from there.
If the court pleases.
Thank you, okay. Thank you everyone. We will now adjourn. Sorry, I will indicate that I will reserve my decision.